26 मतलब
Just
19
19.
19 मैं आपको
Okay.
26
Day after tomorrow, 26, 7, as paid for by the GN Shahla Senior Council.
Made the losses, my lord. Mr. Sayal is my case. He has vacated one seat, my lord, so I want one more urgent unlisted 2 or thereafter. Because emission case, my lord. Only 1 day's game time, today only, in Lambding.
Okay, move it today. All players for listing, please give it to the court master.
His lordship. But on demolition matter, your lordship is urgency. Tomorrow, lordship.
Election officers. Tomorrow, can it wait till day after tomorrow?
Tomorrow, lordship, because today, I don't know. Today itself also the demolition may be carried out. So I am asking for tomorrow.
Made.
Here for listing, give it to the court master.
I have filed an additional schedule.
Wait, I beg to mention item number 7, madam. It is matter may not be taken up today, madam. Next, it is on next week, madam.
7.
7, madam. I'm led by Mr. J. Kamar, madam. Today he is unavailable, madam.
Okay. But otherwise also, I'm only interested in issuing a notice. I'm not giving any interim relief at this stage.
Interim, in fact, we are also not praying for interim at this.
Notice can be issued. Any difficulty in that?
Otherwise, I don't have any difficulty, madam. But I'm led by Mr. Kamar. That is why I'm
Okay. List after a week.
next week, madam. Any day on next
List
week.
after a week as paid for by Mr. N.J. Khadne, counsel to the petitioner. Okay.
Obligation.
With legal lawsuits. I beg to mention item 35. In this case, I would like to file impleading petition, madam. 2 weeks times may be allowed. I took consent from the other side.
Okay, 35. 35.
35, madam.
35, you are not there.
No, I am not there. I would like to file impleading petition.
Oh, acha.
Yes, madam.
Okay. With consent of the other side. Mrs. K. Devi, counsel submits that she is instructed to file a impleading application. So, matter stands adjourned today, list on, next week give a date.
After 2 weeks, madam.
After 2 weeks.
Yes, madam. Because the person who is appearing, madam, his wife is not keeping well. That's why.
Okay, list after 2 weeks.
Highly obliged.
There is an urgent repetition lordship that a market has been settled with the second highest bidder. I being the first highest bidder, I was not settled with the market lordship. And the second highest bidder has been given. And the clause 8 of the NIT was also not fulfilled by the private transport.
Day after tomorrow?
Tomorrow, lordship. Tomorrow, lordship.
Tomorrow is an election matter. I'll be facing difficulties.
Because already the settlement has been given to the private transport.
Okay.
Tomorrow, lordship. Okay.
May I please, resolution? I will mention item number 8, my lord. Maybe taken after 2 weeks, my lord. I have shared instructions from the client, my lord.
Okay. After 2 weeks.
Yes, my lord.
List after 2 weeks as paid for by loan counsel for the petitioner. Just a moment. Senior counsel is there.
Item number 38, in this case, that we have been engaged today. That's why we need that sometime 3 weeks. And
Okay.
to look after the baby.
List after 3 weeks as paid for by loan counsel for the Miss.
And in the and then
Be the third in the senior counsel. For the petitioner.
in the meantime, the interim order 13/7/2023 may continue.
Just a moment. This is item 38. Then I'll have to give you a short date because this is a contract for supply.
Yes, my lord.
I cannot give a long adjournment. Because the order is not to finalize the tender.
2 weeks.
No. A shorter date. 10 days from today. 2nd August 2023.
May I please know?
Huh.
Chief, I beg to mention item number 57 to be withdrawn, my lord.
57.
Yes, my lord. There are multiple errors in the petition. We would like to file a fresh petition.
Okay. Your name?
Miss H. Jane.
Upon instruction, Ms. S. Jain, counsel for the petitioner, seeks to withdraw this petition as on the ground that the petition, there are several mistakes in the petition. To stop prayer is allowed. No, CEC will be there. Yes, Mr. K. Gogoi, CEC is present. Matter is dismissed from the door with liberty to file again.
Obliged.
Yes.
I beg to mention item number 63, my lord. Item number 63.
63.
63, my lord. Contempt matter, my lord. Earlier it was listed 3 times, my lord, but due to procedure of time, honorable court could not take up the matter, my lord. If possible, my lord, before rising, it is not listed.
Okay,
63,
Okay.
my lord. Only one notice will go, my lord, contempt matter.
okay, we'll take it up.
Order.
May I please, my lord? My lord, as regards to item number 24, my lord, I am making a prayer on behalf of Mr. S. Chetia, my lord, for the income tax department, my lord. We have taken consent of Dr. Saraf, my lord, for the petitioner. It may kindly be listed after 2 weeks, my lord.
Okay, with consent of the other side. Here for adjournment is made on behalf of Mr. S. Chetia, standing counsel for responding numbers 2, 3, and 4. There is allowed list after 2 weeks.
2 weeks, my lord.
There is an interim order operating.
Interim order.
Interim order passed today, stands extended till the next date of the same.
Obliged.
May it please a lot. May I pray for slight accommodation, my lord? We find the motion matter. Otherwise, I would pay for tomorrow, day after tomorrow. I'm suffering from a heel problem. It's difficult for me to stand. I may not be available tomorrow, day after. The matter is extremely urgent. I requested Mr. S. K. Talukdar. Could it be taken up at 2 o'clock? It is urgent. Otherwise, I would have not paid for tomorrow. Obliged, Lordship.
May I please? I beg to mention item number 23, lordship. I am for the respondent number 7, lordship. Today, we have filed the affidavit in opposition, lordship. That may be taken with the record. Obliged.
May I please, Lordship? Item number 13, Lordship. May be taken at 6 p.m.
13. Okay. Okay. At 2.
Lordship, I beg to mention item number 58, Lordship. Am I allowed to withdraw, Lordship? Supplementary 58, Lordship.
58.
Oil
So
case.
that oil.
Oil
Okay.
case. Liberty may be given, Lordship.
Okay. Upon instructions, Mr. B. Chaudhary, counsel for the petitioners, seek to withdraw this petition with liberty to approach again. Mr. K. Kadita, standing counsel for Oil India Limited. Mr. M. Chetia, government advocate appearing for the state. And D. Hazarika, standing counsel for revenue present. Matter stands dismissed on withdrawal with liberty as paid for.
Highly obliged.
Lordship, I beg to mention for listing this contempt petition to contempt for orders.
Supplementary cause list item number 54 and 55 for delivery of order.
Print of the line. Hello, Prabhu, actually. Hello, Prabhu, actually. Just wait, I in the chamber. The writ petition is disposed of by delegating the petitioner to approach the appellate authority. But just wait. I'll come. And what is it? 1969. Now that I said. I don't know. Thought of all. Huh. If the appeal is filed within a period of 1 month from today, the delay, if any, in filing of the appeal would be condonable as time spent by the petitioner before this court from 11/3/2020 to 21/7/2023. Subject to filing of the appeal within 1 month from today, the interim order dated 13/3/2020 directed status quo to be maintained and staying of the operation of the impugn order dated 2/22/2020 shall stand extended till the appeal is first listed and not taken up by the appellate court for admission of the adjudication. Needless to mention that if the appeal is not filed within the time allowed, the interim order shall stand lapsed by a course of time. The appeal, if filed, shall be disposed of expeditiously as possible, if necessary, by discouraging unnecessary adjournment. As the petitioners have been delegated to file an appeal, none of the observations made in this order shall prejudice the parties then when the appeal is heard and adjudicated by the appellate court.
Okay, much obliged.
Just a moment, this. There's a bunch of judgments you can take it back from Mr. Saiwala.
Much obliged.
I don't find the amendment. Print out. In this, I have issued a notice
Much obliged.
requiring you to file an affidavit. And that interim order past today stands extended till the next date of listing. I've given a short time. There's some buffer. Printout is not available. But
You collect the record up.
Huh? Yes, yes. Records to provide you. No, it was a lot of without us. It was the other. Yes. Itu আগৰ order 1970. আজিৰ অফিস print of the array. And there was a. Just collect the date after some time.
Lots, indeed.
The records, you can take it back. The record to the. Mr. KL, I was very impressed with the argument, in fact. The presentation of argument was very good. I was very happy with the argument.
But there is a case in Lordship, I discussed with the department.
No, that may be there, but the presentation by the lawyer was
Yes, that is.
very good. You can convey it. You can convey it to him.
Not.
No.
This is, Your Lordship, Mr. Raichandani will be there for the next day.
No, it's okay.
So I think the court would
No,
appreciate him.
I
in
would
this
appreciate,
case itself, Your Lordship.
today's matter is today, not tomorrow.
Indeed, Your Lordship.
Correct.
Much obliged.
Yes. Item number 1.
My lord, matters become infructuous, my lord.
Okay. 1, 2, and 3 are both for, all for withdrawal.
1 and 2, my, we are for 1 and
1, 2, and 3 also. Upon instructions, Mr. H. Chaudhary, counsel for the petitioner, seeks to withdraw this petition as the matter has become infructuous. Here is allowed. Mr. B. Sharma, the standing counsel for NF Railway is present. Matter is dismissed on withdrawal. 1 and 2 same.
2 and
Okay.
obliged.
Mr. A. Barwa. And Miss, you are appearing for government, Mr. M. Chepia, government appeal for government.
Obliged.
You're there?
Your Lordship, in this particular matter, the NIT risk and cost tender has been cancelled and a fresh tender has been issued. So I want to challenge that fresh tender.
Okay.
The matter has become infructuous.
I'll just say it is become infructuous.
Liberty
Challenge.
granted to fire.
Liberty is not required because that is completely different.
Separate
matter.
matter.
Mr. D. Bora for the petitioner.
Hirapa on behalf of Mrs. Agan.
P. Rava on behalf of
Mrs. Agan.
Miss
Agan.
A. Gayan, CGC. For the respondents. Just say that the matter become infructuous as the risk and cost tender has been withdrawn by floating another tender. Okay,
Fresh tender.
fresh tender. Okay, you just mentioned that.
Alias.
Item 4. Lordship, kindly pass over for time being.
No, I'll list it next week along with the records of BA 2779. List on when
Lordship,
Friday?
Lordship, Mr.
20 of August, Lordship, in month of
No, because records are there.
first of August.
Okay, make it 2nd of August.
Okay, Lordship.
So as to enable the Miss
A Begum.
E. Begum, learned APP to obtain instructions. Next list. Now, as the scanned copy of the case records is available in BA 2779 of 2022. The said disposed of BA 2779 of 2022. The tagged when the matter is listed next.
May I please, Lordship?
Yes, sir.
Interest has been demanded from me.
Just a moment. Yes, you have instructions.
Lordship, yes. Lordship, I have received instruction that calculation of 23 is correct. And as per the return submitted by the, everything is being on portal, Lordship. And Lordship,
Let me file the affidavit.
Lordship 43, page 43,
43.
Lordship. Because there was a delay in filing of the return. So it was.
No, that is okay. But the, as for order dated 24 to 2023,
Lordship.
the late payment was done not till the date of actual payment, but till the date of filing of the returns.
Lordship.
That is written in the order.
No, Lordship.
And the court
or
find that this is prima facie correct.
Otherwise, Lordship, petitioner can approach the concerned commissioner and he can verify their Lordship. We said pending writ petition here. If that is because in rare,
No, the authorities must only say one thing, whether the payment of interest would be till the date of actual payment or till the filing of return. If either of the two is correct, the petitioner succeeds or the case is dismissed.
okay, Lordship, then I'll file a petition. Allow me 10 days time. But
Either that or written instructions, because you see, the petitioner must know where they stand.
Lordship,
Either an affidavit or written instructions. You can give a copy to.
I'll file a petition.
Huh?
I'll file a petition.
For Mr. D. Saraf, counsel for the petitioner, and Mr. S. C. Kyal, standing counsel for the CGST. Next para. Contrary to the observations made in order dated 24 to 2023, the learned standing counsel for the for the respondents has submitted that as per his instructions, the calculation of interest is correct. Next para, be that as it may. In view of the stand taken, the respondents may either file an affidavit in opposition or produce a set of written instructions with a copy to the learned counsel for the petitioner. List on when
Up to 10 days.
10 days.
There is an interim order, Lordship. I pray for extension of this.
Huh?
There is an interim order, Lordship.
Okay. When date?
7-8.
7/8. Interim order passed on 28 to 2023 stands extended till the next date of listening.
Lordship, extra copy in the time.
Two extra copies. Sir, notice is not issued.
No, no.
Oh, actually, then if you notice, returnable on so and so. Extra copy in course of the date. Interim order extended.
Much.
Obliged.
6.
I'll have to issue notice. I'll have to issue notice. Your appeal was dismissed. You filed for appeal.
Non-appearance lordship. Our
You
allegation
filed
is
for
that
restoration.
notice was not ever issued to us.
No, it's okay,
It should
but,
not intimated.
but I can't pass an ex parte order. I have to issue notice. But Dr. A to D, counsel for the petitioner. Who will appear for that? Mr. Gogoi.
Gogoi is appearing. here.
This is called State GST.
P. Gogoi.
D. Gogoi. SC State VAT. Abu Dhabi. Just wait for some time. Orders pass in presence, he will.
Otherwise, they will ask to take instructions. Lordship.
No, that I'll do, but he must have notice so that it's what do you call faster.
Nine.
Yes. I intend to pass an order to allow them to harvest the.
Nine.
Item number, it is item number 9, petitioner will amend the first title, Lordship, Lordship may pay last August. On 23rd, 6th.
I think that is done. That is done.
Then notice may be issued.
I'll issue notice, let them harvest it. They may not have any, what you call, they may not have any other interest but to harvest it. If they have crops, I find it very difficult not to give an interim order.
Regarding this, Lordship, we have to obtain instruction, Lordship, regarding the present
To
situation.
do it, we can issue a short, because you see the harvesting time will go. This time it is flooded, I think crops have been damaged. Whatever has remained, I think by August, the harvesting season will be there. So after that, don't allow them any,
I allow 1 week time to obtain instruction also.
no, but you see, if the crops are no longer there, after 8, 10 days, nothing will remain there. It's only the harvesting of crops.
Got
You may not allow them to stay there, but harvesting of crops, I don't think that will be so inconvenient. Because you see, the farmers, they put their life when they are in the sowing field. Not only time and energy and money, but they spend their best part of life doing that. None appears on call for the petitioner. Next para. Pursuant, it is noted that pursuant to order dated 23/6/2023, the cost title has been amended by including Messrs. Guru Khuti, GORU KHUTI, multipurpose agriculture project as respondent number 5. Next para. In view of the nature of the advanced stage in the present petition, issue notice of motion returnable. You want 7 days?
Lordship.
Returnable on 2/8/2023. Requisite extra copies of the writ petition be served to the learned. Ms. G. Hazarika, learned standing counsel for
Respondent number 1 and 2. Lordship.
for Revenue Department accepts notice on behalf of respondent number 1 and 2. Mr. M. Chetial, also you are there, Mr. G. Bokalian, learned government advocate accepts notice on behalf of respondent numbers 3 and 4.
Right.
Requisite extra copies of the petition is served on the learned state and departmental council within 2 days. Next paragraph. Petitioner shall take steps within 2 days for service of notice on respondent number 5 by registered post with AD. In addition, the petitioner is also granted liberty to serve notice on respondent number 5 by way of Dasti by routing the process through the registry of the court, and upon service and affidavit of service shall be filed prior to the next date of the state. Next paragraph. Considering the projection that the petitioners are projecting to have cultivated crops like rice, maize, chili, jute, and several varieties of vegetables. In the land holding, which is more in the land which is more fully described in paragraph 4 of the petition. The court is inclined to provide that the petitioners shall have liberty to harvest the crops which will not create any right title, interest or position in favor of the petitioners. Once the harvesting of the present crops are done, the petitioners are prohibited from raising from planting fresh crops on the land described in paragraph 4 of the writ petition. Next one, the petitioner shall produce a certified copy of the order before the respondent number 3 and 4 to bring the order to the notice of the said authority. Next paragraph. The respondents are at liberty to move the court for modification, variation of the order if so advised. And based on 2/8. Yes,
May it please your lordship. My lord, here the petitioner and the private.
there is a suit pending.
Yes, suit.
Any difficulty in filing an injunction application in a suit?
Only difficulty, my lord, but actually it has come to our head. My lord, since the deputy commissioner is not a party to it, in the suit. So, my lord, it would be difficult for us to pay for injunction, my lord. Since we have only filed for specific relief, my lord, and defendant is the respondent, private respondent here, that is 9, my lord. My lord, my representations are there pending before the concerned authorities, my lord.
No, you see,
My lord,
this is something which I find it difficult to accept. You see, this is a land acquisition case.
yes.
Land acquisition is done under which act? In this case, land was acquired under which act?
My lord, by from that, I have placed it at my lord page 31.
And just tell me which act?
Act will be, my lord, this is by the National Highway and Infrastructure.
Okay. So has anybody prohibited you from applying for the disbursement of compensation, disclosing your right before the said authority? The competent authority is the nominated officer, additional
Yes.
deputy commissioner.
Yes,
Has anybody prevented you from going to that office?
going to the, my lord.
To go to that office?
We have went there, my lord.
Then
We went there. We have that is why, my lord, these representations were made. And but now we have come to know, my lord, at any point of time it would be released. That is the difficulty. Because, my lord, long back
where is your representation?
representations are, my lord, from also will find from annexers, my lord. Page 63 onwards.
53 onwards.
63
63.
onwards.
You see, first representation is before the deputy commissioner.
Yes, my lord.
Under National Highway Act, the deputy commissioner is no authority.
But, my lord, the disbursement.
I don't know, you see. I'm just telling you.
Yes,
I know limited from the act.
yes.
The act says the additional deputy commissioner who is the concerned officer, right?
Right. My lord, we have made it.
Competent authority is always additional deputy commissioner. He is
So
Kala
that's what I'm
Rashid.
asking. It's a
yes.
additional deputy commissioner.
My lord, we have made a copy to him also. It
No,
is
no.
at next page, my lord. Lord
No,
will
no,
find.
government doesn't function like that.
Yes.
You see, let us assume that one of the representation is sent to the governor.
Yes.
Originally sent to the governor. Second is sent to the revenue, the copy is given to a revenue officer, circle officer. You think circle officer will pass an order?
My lord, that's true. But deputy commissioner, my lord, we have filed it. And along with that, my lord, we have served through, my lord, to the additional deputy commissioner also. Probably, my lord, we should have filed directly to him. Anyway, my lord, as deputy commissioner is.
No, we will provide you to give a representation to the said authority, who is the
Yes.
competent authority. And with the experience I have,
Yes.
Ms. Singh will be able to
Kala-
convince
Kala
them,
is,
because once you lodge a appropriate application
Yes.
for claiming your right, I don't think the deputy commissioner will release you money. Ms. Hazarika is there to catch the deputy commissioner.
Fully additional deputy commissioner come Kala Buli Likhibo.
Yes, my lord.
Competent authority for
right.
land acquisition.
My lord, may I
Thank you.
pray till then, my lord, may not be.
No, I'm not giving an interim order. You are at liberty. Today also you can go and give the representation.
Yes.
Heard Mr. T.H. Hazarika, counsel for the petitioner. Also heard Mr. G. Vokalial and the government advocate appearing for responding number.
As per number 4,
No,
5.
I'll go serially. It is easier in the order. CGC, Sir K. Gogoi. K. Gogoi, learned CGC, appearing for respondent number 1. Ms. G. Hazarika, standing counsel for revenue department, appearing for respondent number 2. Mr. G. Vokalial, learned government advocate, appearing for respondent numbers
4, 5, 6, and
5,
7.
6, and 7. Ms. B.L. Singh, learned standing counsel for respondent number 8.
NHIDCL, madam.
Huh?
NHIDCL.
NHI DCL. Next, in view of the order proposed to be passed, issuance of issuance of notice on the respondents, including private respondent number 9, is dispensed with. Next para. The petitioner claims to have instituted a suit being TS number 55 of 2023 seeking specific performance of contract and alternatively for recovery of advance provided for sale of the land described in the schedule to the said plaintiff. Stop. During the pendency of the said suit, the petitioner has come to know that the suit land has been acquired for national highway, and accordingly the petitioner has moved the has submitted representations to the Deputy Commissioner Nagaon to hold the payment of compensation till the disposal of TS 55 or 2023, which is pending for disposal before the court of Learned Civil Judge Nagaon. Next paragraph. In the said context, the Learned Standing Council for the NHAI DCL has submitted that the disbursement of compensation for land acquisition for national highway is not done by the Deputy Commissioner, but the additional Deputy Commissioner dash come competent authority for land acquisition within bracket CALA for short is the competent authority to decide on the issue relating to disbursement of compensation. To stop. Accordingly, it is submitted that as the representations is not directly addressed to the said authority, it is quite possible that the competent authority of land acquisition has not taken note of the said representation. Next paragraph. The contention of the Learned Council for Respondent number 8 is supported by Ms. G. Hazarika, Learned Standing Council for the Revenue Department. Next paragraph. Either as it may, as the Learned Standing Council for Respondent number 8 has disclosed that the appropriate and competent authority to decide the issue of disbursements of land acquisition compensation for land acquired for National Highway is Additional Deputy Commissioner Kala Kamanova. The petitioner is this regulation stands closed with liberty to the petitioner to move the said authority with such prayer as the petitioner may deem fit and proper. First of the petitioner is at liberty to support the representation to be filed with the certified and or downloaded copy of this order. Mr. Hazarika, since you have readily accepted, I have not passed any adverse orders because you see, otherwise your petition is liable to be dismissed, and I'll tell you why. Number one, you have just entered into an agreement for sale.
Yes.
Correct. So either you will get the land or you will get back your money.
Yes.
But you have no lien over the land acquisition compensation.
Yes.
I'm saying so because there are authorities on the point. You have a right over the land, but insofar as compensation is concerned, the right will devolve on the owner of the land.
Yes.
To receive compensation. You can have an order of attachment before judgment and get it attached. Correct.
Right. I got
So legally, that is the way out.
Yes.
But since you have accepted, I am not passing any adverse orders.
Yes.
correct?
Yes. That is true, my lord, because I have not acquired right till now.
No, but still, since you have accepted it, I am not passing any
Yes.
adverse orders. But
I'm
I'm just
deeply-
telling you,
Yes,
had you contested it, I would have gone
yes,
against it.
I understand. Obliged, my lord.
Yes, Mr. Gogoi,
Yeah, actually, my lord,
it's okay, I'm issuing a notice only, but I wanted to pass orders in your presence so that you can get instructions faster. When do you want?
Well, let it be after 2 weeks, my lord, for the instruction whether notice was served or not. That is the main issue.
Huh.
Before dismissing the.
No, not even that, it is, once it is dismissed or devolved, it can otherwise also be restored.
Yes.
That discussion we have,
My lord,
only that much.
my lord,
The notice
I
may
will-
be served, may not be served,
my
but
lord,
once it is dismissed on non-prosecution,
Lord.
maybe we can, that can be controlled.
No, that's why, my lord, the instruction that was I supposed to have, my lord, is that, my lord, whether notice was served to the petitioner informing that particular date. If it was
No,
served,
we
despite
can,
it,
we can take it adverse. Let us say that
Yes,
he has
yes.
received it.
Yes.
Then also he has defaulted.
then also, yes, it will be a default.
Still, we can go ahead.
Then, my lord, after, my lord, 10 days or 1 week, my
2
lord.
weeks.
My lord,
Because once it is already dismissed, I don't think there will be some
Lordship,
incident, only that much.
Lordship.
Had Dr. A to D, counsel for the petitioner, and Mr. B Gogoi and Mr. Tanikosi for the
Finance
respondents.
taxation, my lord, yes.
For the finance and taxation department, appearing for all the respondents. Next for that. The appeal filed by the petitioner was dismissed for non-prosecution. And accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has paid for a direction to restore the appeal for hearing. Next, issue notice of motion, returnable on, give a fixed date after 2 weeks.
9 minutes.
9 minutes. List also mentioned. Issue notice, returnable motion. Requisite extra copies of the writ petition is served on the department counsel in course of the day. That's why we hope that as the issue involves a short question from the respondents. Sir, either file the affidavit in opposition or provide the learned standing counsel with appropriate instructions. List on 9/8/2023.
11.
And dispose of this matter, let the authority pass a order. Once he has cancelled it, suspended it, he has to hear the matter.
Yes, madam. Right. In fact, my lord, it is a nice absconding matter as per the power of this.
That is for the another bench to take care of that.
Yes, madam.
But then you should have hurried. Then you should have hurried. You should have fixed a short date. You have seen yesterday's, yesterday or day before yesterday's newspaper. You have seen that? Assam Tribune. There the authority was smart. Somebody was absconding and the authorities issued a newspaper advertisement with full notice of attending departmental inquiry. It was more than a page. 1 page of advertisement. Giving a notice, and this man is absconding. It's also recorded in the orders. The man is absconding. Now the party has no choice. He either subjects him to the jurisdiction of the authorities or the departmental proceeding is ex parte. Ask them to read this and learn. Heard Mr. S. Hawk, counsel for the petitioner. Mr. Hawk, don't present the writ petition in this manner. In the notification, we have already said what would be the font size, how many lines, how many. Your writ petition doesn't conform to that.
Pardon me, my lord, I could not hear my lord. I could not got my lord time.
The writ petition you have filed is not as per the prescribed format. Font size is different.
Oh, yes, ma'am. I'll
Don't
take
do
care.
it.
My lord, I'm sorry.
At times when
I'll take care of it.
when we are not in good mood, you may find yourself in a difficult position.
Right.
Also heard Mr. M. Setia, counsel for the government,
Respondent number 2, 3, and 4.
government advocate appearing for respondent number 2, 3, and 4. Prior to that, Mr. C. Hazarika, standing also for revenue department, appearing for respondent number 1. Next paragraph. The and also somewhere in your repetition, you have written the Assamese word, Mohara. I don't know whether that is the correct word because Mohara is normally used in PWD. There it is not called Mohri, there it is called Mohara. PWD doesn't say that Mohara is, I think, used there. PWD. In Assamese, they are either called Korani or they are called Mohri. No, whatever way, but somewhere you have written Mohara.
Yes.
The petitioner is a petition writer having a license from the district registrar within bracket registration, Kachar, Silchar, bearing license number 1 dated 31/3/1997. Stop. It is proceeded that it is projected from the where is the impugn order? Huh?
Order was issued, my lord, but order was issued, my lord, but I was debarred
From the paper publication, he has come.
Where is that?
Paper
Page 23, my lord.
23.
25,
So 25, my lord, sorry. Paper publication is page 26.
and in fact, my lord, he was also debarred, not allowed to seek.
On the as per news article appearing in the Dainik Jugasankar edition dated 24/2/2022, the petitioner is found involved in corrupt practice and therefore the concerned police are searching for him. And in the meanwhile, the license of the petitioner as petitioner writer was suspended. Please stop. The learned counsel for the petitioner projects that he has not been served with any, that the petitioner has not been served with any order of suspension of trade of his license, but he has been restrained from appearing before the various officers under the district registrar within bracket registration, Kachar. Accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the suspension of his license and has paid for restoring his license as petition writer. Next, in view of the order proposed to be passed, issuance of notice on the respondents is dispensed with. Next paragraph. It appears from the news reports appearing in Dainik Jugasankar that the petition writer's apostrophes license of the petitioner was suspended. Therefore, the district registrar within bracket registration, bracket to Kachar Silchar, who is the competent authority, would require the petitioner to be heard and bring the issue to a logical conclusion. Accordingly, accordingly, the court is inclined to close this petition by allowing the petitioner to submit a representation before the. No, no, just let me hear. Hear me. Filing a fresh representation before the district registrar within the registration. Kachar Silchar with appropriate prayers. And on receipt, along with the certified copy of this order. First of all, on receipt of the same, comma, the district registrar within the registration. Kachar Silchar within bracket respondent number 3 shall fix a date of hearing not greater than 2 weeks from the date of receipt of certified copy of this order and herein dispose of the matter, preferably within a week thereafter. Because the livelihood of the petitioner is at stake. Within 1 week or 2 weeks? Within 2 weeks, he may like to give evidence. Within 2 weeks.
2 weeks.
First of the as the livelihood of the petitioner is at stake, the petitioner shall be permitted to appear with his learned counsel at the hearing on his representation. Next paragraph. The representation stands disposed of with observations as indicated above. With observations and directions as indicated above. Next paragraph. In the meanwhile, the learned government advocate shall also transmit a downloaded copy of this order to the respondent number 3 to bring the order to the notice of the said authority.
I am obliged.
Well,
May I please use your lordship? Your lordship,
no, first, Mr. Sarini has not moved.
My lord,
Unless he moves, you can't
I
give a
think
reply.
my lord, my learned friend want to help me, my lord. My lord, anyway, my lord, my lord, Mohol has been entrusted to me, my lord, 2015, my lord. I ran up to 19, my lord. There are another Mohol has been, my lord, settled, disputing my lord, my Mohol. Thereafter, my lord, I lifted the my lord sent till my lord 19. Then, my lord, I
No, but
submitted.
the question is that, Mr. Sarini, the question is that whatever be the reason, now you are asking to return the last 2 kiss money.
My lord, that
No, that is a disputed question of fact.
my lord.
The read court cannot.
No, my lord, lordship may come to the order, my lord, order annexure, my lord. 10, my lord.
Yes.
Lordship may come to page 39. Having regard to the above and
Just
on the
one-
agreement.
just- just a moment. Page
39,
39.
my lord. They have been
Yes.
asked to demarcate the boundary, my lord.
No, I understand.
That's why, my lord, they have
No,
not
let us,
done.
no, let us say they have not done.
My lord,
You are otherwise on fact, you are right.
my lord.
But still you are asking for refund.
My lord, that refund, my lord.
But who will do that calculation? The High Court doesn't do it.
No, my lord, but I have submitted represent that has been not disposed of, my lord. Annexure 14. Page
So we can only
46.
direct them to dispose of a representation. We
That's
can't do
right.
anything else.
That's my.
your lordship,
Because you always also have a right to pay for a remission. You also have a right to pay for a remission.
My lord. Well, whatever security deposit and the 2 kist money, my lord. October
Yes.
to
Ms. Das?
March 2020.
Your Lordship, page number 35, Your Lordship. For same cause of action, Your Lordship, two read petition has been filed, Your Lordship. That is Annexure 9, page 35. Order has been passed on dated 2011-2019. And that matter stands
Are you very
disposed
sure?
of earlier.
Are you
Your
very sure
Lordship.
it is same cause of
And that
action?
same cause of action, Your Lordship,
Are you-
Annexure 10.
Are you very sure that it is same cause of action?
Your Lordship, page 10 and Annexure 10 and Annexure 9, Your Lordship.
Page, give me the page number,
Page 37, Your Lordship.
37.
30,
Yes,
38 and 39.
yes. But are you very sure? You have read the earlier read petition?
Not. Court has interfered, my lord, in the second repetition also, my lord.
Yes, Your Lordship.
We'll take it up at 2 o'clock. You must have copies of the earlier read petition.
Earlier with petition, we don't have, Your Lordship.
Then how can you make a statement, bold statement that the cause of action is same?
Order, Your Lordship.
No.
Then
You
Your
see,
Lordship, on
Ms.
contracts
Das,
to the
Ms. Das, let us say that a person is filing representation after representation. After every representation, he comes to the High Court. Will it be the same cause of action? You see, once you say same cause of action, then it will entail dismissal of the writ petition. Please be very sure. We'll take it up after 2 days if you want. Because it will be your burden now, once you take that plea. We'll take it up day after tomorrow then. Yes,
My lord, maybe on Friday, my lord.
Friday, okay.
These 3 days I'll be not.
Mr. M. Saranya, counsel for the petitioner is present. Ms. P. Das, standing counsel for the BTC.
I'm appearing on behalf of Pina.
Asha, on behalf of Mr. P. Nayak, standing counsel for BTC, has raised a preliminary objection as to maintainability of the writ petition on the ground that for same cause of action for which the present writ petition has been filed. The petitioner has earlier approached this court by filing WBC 8550 2019 and WBC 3092 of 2020. Accordingly, the learned counsel for the petitioner shall supplement argument by producing the copy of the earlier writ petition, the writ petitions. So as to satisfy the court that the petitioner has approached this court for same cause of action. List on Friday. 28, 7/20.
My lord, my lord, misconceived, my lord. There was a regarding boundary dispute, my lord, about the Mahal.
It's okay, she has taken a
Now
ground.
this is for representation, my lord. This was the
She's
representation, my lord.
taken a
But I am
ground.
bringing only the facts, my lord, to convince the honorable court, my lord.
It's okay, she has taken a plea.
My lord,
She'll have to satisfy the court.
my lord.
14. Okay. I'll issue notice.
Yes, my lord, even my lord, order was passed by Sakul Loksa, my lord. Then in case, that case, my lord, he can oppose the deputy commissioner, my lord.
There, my lord, position, actual position has been, demarcation has not been done, my lord. Only that works, my lord. I am the highest, my lord.
There is a statutory appeal, my lord. As per land regulation.
Pardon me.
There is a statutory appeal, my lord, as per land regulation, my lord, 147, my lord.
No, you see, the problem lies with the government. These officials, they are multiplying the petitions in our court. You see, I don't know the facts inside, but come to synopsis, the last page.
That is correct, my lord. After.
They say
the
that
order,
whatever be the
within
result,
1
they have
week,
given a
my lord,
representation.
yes,
You know, you don't dispose of the representation. I can't help it.
Yes. And all other also given, my lord.
But Mr. B, I forgot the name,
Is thus.
H. Das, counsel for the petitioner. Also heard Mr. M. Chettiar, I'm a government advocate, appealing for the respondents. Next paragraph. Agreed by non-disposal of the representation dated 10/5/2023. The present petition has been filed under Article 226 of the Constitution of India by positing that if the representation is not disposed of, it may result in cancellation of the allotment granted to the petitioner in respect of Kharsutha, Kharsutha, Mean Mahal, MINMAHAL. Next paragraph. At the outset, the learned government advocate has submitted that against the order of cancellation of settlement,
Yes.
Statutory remedy by way of appeal under section 147 of the Assam Land and Revenue Regulation. It can be filed. According to the learned counsel, according to the petitioners of the petitioners put to notice of non-exhaustion of the statutory remedy. Next, issue notice returnable in 2 weeks. Requisite extra copies of the, we'll make it shorter time.
Yes.
2 weeks.
Chiefs.
Return in 2 weeks. Requisite extra copies of the petition be served on the learned government advocate in course of the day. Next paragraph. The tendency of the repression shall not be a bar for the which authority?
Managing Director, Assam Mean.
Assam, Managing Director of Assam Fisheries Development Corporation Limited to dispose of the representation filed by the petitioner on 10/5/2023.
Yes.
Next, the petitioner shall produce a certified copy of this order before the respondent number.
For the respondent number, my lord,
2.
2.
Bring the order to the notice of the said authority. Okay.
But next, in the next representation date will be different, 9/7/23, and settlement is Sagmaram.
Date of representation is
9/7/23,
9/7/23, and the name of fishery is
Sangmara Bill. Sagmara. Mean Mahal.
Chagmara, CHAGMARA, Mean Mahal.
Yes. The district of Borpeta.
Okay.
15.
This has to be stayed, Mr. Goi. This order is without jurisdiction.
It was issued by the
APDCL, who is there?
FTC authorities.
The AFDC. No, not this. 16. 16. Yeah, madam. 15, say, madam. 16. Yes, this has to be stayed. Third party right could not have been adjudicated.
review pending before the,
No, even the power of review is not there.
there is a statutory appeal provision also
That is also not necessary because third party rights have been adjudicated.
adjudicated.
Can they do it?
There is a.
Because then there is no need for a civil court. I want to evict my tenant. I'll say that they disconnect the electricity and I go to the consumer forum of electricity board and they will pass an order of eviction. Why do I need the civil court then?
Admittedly, my lords, the payments were made. However, the bank failed to process those checks that were issued was the APDCL by the complainant. There's another issue that perhaps my lords have
No,
to
but you
point out
see,
is
it's a consumer grievances judicial forum.
forum created under the Electricity Act.
So what about the third party rights? Can it be done?
To that, my lords, perhaps my lords not, should not have been done.
In the
But
meantime,
my lords, the original complainant, my lords, is not before my lords. The original complainant who had filed the complaint before the CGR.
no, because he's not the petition is not agreed by him. He's agreed by the order.
Otherwise is in his favor, my lords. He's probably should be arrayed as a respondent at least, my lords.
I didn't get it. Please.
The original
because that-
complainant before the Consumer Redressal Forum, my lords.
Hmm.
Which is,
No, but in the order, the liability is on the bank. Is it not?
liabilities, of course, cannot be saddled upon the bank, my lords. The amounts were not processed by the banks. The checks were deposited by the
So,
original
because you
complainant
see, then it is the matter between the complainant and the complainant or the consumer and the bank.
and the bank.
The redressal forum, this is not a consumer dispute.
Rightly, wrongly, my lords, there is an order. But they've also filed a review, my lord. That review is pending. There's also an appeal provision under the statute.
No, once it is without jurisdiction, we don't have to delegate them.
But the review otherwise may be, my lords,
I say that review may be disposed of in the meanwhile.
Well, that original complainant also is not before my lord. Remember, Assam Tubes Limited would file the complaint before the CGRF.
No, but is it required? Is he a
See-
necessary party in this litigation?
But the order otherwise is in his favor, my lord, the party's favor. Any
Oh,
interference with that
Right,
order.
right. Right. Your name?
Yes, S Chakraborty. My lord, we submitted representation to the.
No,
forum,
no.
And they have
No, no, no.
admitted our representation.
Nothing doing. You impede the party. He is right.
And regarding the rules of the board, they are not allowed to accept.
No, there are two things you
outstanding
see.
check.
Ms. Chakraborty, there are two things. Number one, in a case of non-general or necessary party, you can rectify the mistake by impeding. But if you contest it, then we take it up on merit. Are you contesting that issue of non-general or necessary party? If you are arguing on that, please proceed.
Yes, technically.
No, definitely means what? You want to contest it or you don't want to contest it, you want to impede?
We will impede.
Then do it. Ms. S. Chakraborty, counsel for the petitioner is present. Mr. B. Chaudhary, known as standing counsel for the APTCL, submits that the writ petition is bad for non-genre of the original complainant as a party respondent in this writ petition. Next, the learned counsel for the petitioner prays for his grievance devotee to complete the party is in whose instance CP case number 24 of 2021 was registered and adjudicated. The impeding may be done in the presence of, it shall be done in the presence of registrar within the judiciary. And the learned counsel for the petitioner shall provide amended cost title to be inserted in the writ petition with a copy to the learned standing counsel for the respondents. Number one. Implemented as respondent number two. This is the matter thereafter in the motion column.
Highly obliged.
17.
My lord, before 17 lordship.
Yes.
Lordship, we apology, lordship, apology in respect to item 14 and 15 lordship. We have taken wrong file. So lordship may only delete that part appeal provision. It is FDC method, there is no appeal provision lordship.
Which one?
Yeah, I don't know.
Item of 14 and 15, my brother is appeared to see in that
I
matter.
have also confused my lord.
In that matter, lordship, we have taken a wrong file, lordship.
Oh, acha.
That lordship 147 appeal provision is not there. Only that part my lord may delete, other is
Okay, 147 provision.
lordship. We have another file revenue matter is.
No, it's okay.
Lordship.
It's okay.
Lordship.
Once you find out your mistake, there's no issue. Okay. Yes, item 17.
In this case, my lord, the petitioner is before your lordship, my lord, is it's involved in maintenance of telecom towers, etc. My lord. Now, my lord, what will happen, my lord?
No,
There
but you'll
are
have to give some deposit. There's a precondition of stay.
My lord.
There's a huge amount due from you.
Yes, my lord.
How much is the amount due?
Amount, my lord, they have, my lord, initially, my lord, as per our calculation, it's, my lord, the surcharge is not to be, my lord, paid, my lord. Therefore, my lord, we pay the principal amount. Even, my lord, the surcharge amount which was not paid, my lord, is, my lord, 1 crore 10 lakhs and all. Now, they have made a demand of 1 crore 71 lakhs and all, without, my lord, informing us anything or giving any breakup as to why this amount has.
We'll give it
swelled.
by 2 o'clock today.
The concerned official, my lords, now we can, my lords may take it up tomorrow, my lords. I'll come back with the instructions. The
Not
amount-
tomorrow, day after tomorrow. Tomorrow I am tied up.
Only the anxiety is that, my lord, they will, my lord, so far as these sites are concerned, these are non-radiating sites. My lord. There's no difficulty in that. So for the radiating sites are concerned, my lord, that's, my lord, since they give given notice, my lord, they'll be.
No, you see, the first issue raised is the non-granting of you the breakup.
And, my lord, whether, my lord, since, my lord, it was under such a waiver scheme, my lord. My lord, they have.
No, that was rejected.
No, well, they have given different reasons. First, they say, my
No,
lord,
whatever be the reason,
My
but
lord.
they have rejected it.
My lord.
And against that rejection, this reparation is not, I think the challenge is not against that rejection.
There is also there.
There is a
Because,
challenge to that.
that's also a challenge.
That's not
also
a
a challenge.
challenge.
Yes.
Then I have missed it.
Yes. Because our case is that, my lord, the surcharge waiver scheme, my lord, we pay the principal amount in its entirety. Therefore, my lord, the surcharge amount is not payable. Now, they, my lord, initially say that, yes, the board of directors have, my lord, decided, then they said that it's not, we are not entitled. My lord, then they say we are not entitled in the scheme. So 3 different grounds have been taken at 3
So
different.
where is that scheme?
My lord, scheme lordship will find, my lord, at page, my lord, 76, my lord. We are covered by B, my lord, at page 78, my lord. Scheme B, my lord. B1, my lord, 100% waiver of surcharges, my lord.
Just, I'm not.
78. 76 is the type copy of the first page, my lord. 77 and 78 is the office memorandum.
What is PDC
PDC, my lord, is the permanent disconnection.
Permanent disconnect.
and TDC temporary disconnection?
temporary.
Consumers.
Okay.
Both, so
And
you paid the entire amount.
we have paid the entire principal amount. I've given a chart of, my lord, what
Where is the date of payment?
date
where
of
do you
payment, my
find
lord, the 23rd of, my lord. I've given the date also, my lord. That's in paragraph, my lord. My lord, the 24/1/2023, my lord, we paid, my lord. Paragraph
20?
22, paragraph 22 have stated. my lord.
No, just give me the date of payment.
Yes, my lord. 24/1/23, my lord.
24/1/23. Mr. Chaudhary, you dispute this payment?
My lords, I'm not disputing the payment, my lords. What I'm saying, my lords, there is a waiver scheme, my lords.
Yes.
There are certain charges that are due. There's a principal amount and there's a surcharge amount, which is basically a penalty on delayed payments of the bills raised by the APDCL. my lord. Now, we have come out, the APDCL had come out with a waiver, surcharge waiver scheme. Now they wanted to apply under the scheme, they should have applied for it, my lord. What they did was they went ahead and made the payments without ascertaining the amount that was actually due. So now, as if my lord.
Those are
kindly
very technical.
Now, my lord,
Those
kindly
are
sees
very, very
page
technical.
324, my lord, the impugned communication from the APDCL. It is clear, my lords, along those lines.
Page
324, my lords.
324. That will be a very technical approach. In
No,
fact,
my
you see,
lord,
instead of writing letters, I make the payment.
No, look,
Well,
we have,
because-
we have paid according
Because
to
the
their bills,
principal-
my lord.
My lord, the communication from the APDCL of 27th April 2023, my lord.
Page
324, my lord, 324. In response to your letter, I would like to inform you that the APDCL allowed the surcharge waiver by so and so dated 2nd January 2023. As per the terms and conditions of the scheme, all PDC, TDC consumers from both LT and HT categories were covered under scheme B, which allowed for waiver of the entire amount of arrears surcharge on
No,
payment of
then
100%.
You're right. The application is not made within the time. You have made the application on 7/4.
No, well, application was made in time because
Where is that?
we have
Well,
paid
it-
according to the bills, my lord.
Where
In
is
fact,
that?
we have been writing to them. These are the bills, my lord, raised by them. It's not, my lord, that our calculation we have paid, my lord.
No, it's okay, but
ma'am.
what is the date of the application?
My lord.
There's no application now.
My lord, 18, my lord, page, annexure 14, my lord.
Just one,
Annexure 14. my lord.
just one.
In fact, before that also.
Just one.
My lord.
Yes, which page?
The lordship will come to page 81 first, my lord.
81.
Yes, annexure 11. Here, my lord, we have given a chart, my lord. We have said that we'll be paying, my lord, 1 crore 24 lakhs and all. However, 187 bills have already been reconciled from several offices and got accepted by us. We will process the same for further payment. Please find below the summary of the so and so. Then, my lord, we even asked them to, my lord, furnish our, my lord, their bank account details, my lord. They've furnished the bank account details. My lord, page 88, annexure 12. This is a mail, my lord, dated, my lord, 19th of January, within time, my lord. As discussed today at your office, we are eagerly waiting for a confirmation and bank account details. As per your requirement, we have already handed over the file of 187 NR bill copies, hard copies, to your office yesterday. And also soft copies have been sent through mail. So, sir, please
Then we
expedite.
will issue a notice.
Right.
They will deposit the amount of rupees 50 lakh, which will not be appropriated.
And they continue to pay the
Current bill they will pay.
current bill
Current bill without surcharge.
without such, of course.
Current bill will be without surcharge. Because his payment and applications are before that, before your due date of closure.
But my lords, admittedly, the amounts were not reconciled. my lord. That is the whole issue.
I think will be too technical.
Very well.
You receive the payment, you don't dispute it.
We are not disputing the payment. We are not disputing the payments.
And the petitioner says that you tell us the dues. The breakup, you tell us the breakup.
Very well. A short notice, my lords.
For Mr. M. Datta, counsel for the petitioner. And Mr. B. Chaudhary, on standing counsel for the APDCL. Appearing for all the respondents.
All the rest.
Next paragraph. And Mr. Datta, you better ask your clerk. What do you call, they should not be more smart than the office. Who the hell you? What my other people are there? हाँ? हाँ? नहीं এখানে লিখি দিয়ে তো हमारे में हाँ नहीं देखा दियो नेक्स्ट टाइम को ना लगे the case projected by the petitioner is that they had approached the APDCL under the surcharge waiver scheme. You see, unnecessary that July has come.
Yes, sir.
Don't do it, it distracts me.
Well, I'll help.
Yeah.
Sorry, Madam.
Because I have a bad habit of reading everything. Everything is not 100%, obviously with some what you call flipping here and there. Under the surcharge waiver scheme, which means the APDCL had issued a surcharge waiver scheme envisaging a period of period from July 2023 to 25/1/2023, and that if any person applies under the scheme capital B-1 for 100% waiver of surcharge, the mandate under the office memorandum dated 2/1/2023 is projected that payment of 100% principal amount was to be made at one time within the period of the scheme. Full stop. The case projected by the petitioner is that 100% principal amount was paid on 24/1/2023, for which communications were made with the PDCL authorities, and on the account details being provided, the money was transferred to the bank account of the APDCL. However, the application of the petitioner for 100% waiver of surcharge was rejected by the board of APDCL on certain grounds. Accordingly, the present petition has been filed under Article 226 of the Constitution of India, assailing the demand for a sum of rupees 74,22,087.
Well, now it is 1,71,071.
Which is now increased to rupees
1,71,071,53.28.
Please be slow.
1,71,071,53.28.
0.28. For question of the APDCL communication dated 25/3/2023, as well as communication dated 27/4/2023, by which the prayer of the petitioner for waiver of surcharge was rejected. The petitioner is also assailed the letter dated, the communication dated 23/6/2023, demanding deposit of the sum of rupees, the same of 171,07,153.28 within 18/6/2023. Among others, so and so. Next paragraph. Issue notice. Including notice on the prayer for interim relief returnable on when Mr. Machodi.
2 weeks, Madam.
within 9/8/2023.
9/8, my lord.
9/8, requisite extra copies of the writ petition will be served on the Government Departmental Council in course of the day. Next paragraph. In view of the demand for a sum of rupees 1,71,07,153.28, the court is inclined to stay the said demand, subject to deposit of a sum of rupees 50 lakh to the respondent, to the concerned respondent authority within a period of 15 days from today, within the next returnable date. Within the next returnable date. Full stop. The said deposit, it is also directed that the interim deposit made by the petitioner shall not be appropriated by the respondents. Next paragraph. The pendency of the writ petition shall not be a bar for the petitioner to pay the current energy charges. Next paragraph. The quantum of surcharge, if any, shall be subject to further orders of the court. No, this I am saying, please understand this. This I am saying for the purpose that in every energy bill, you raise surcharge.
Yes.
So those will not be added here, but the surcharge can be billed separately, so that the same is subject to
The outcome.
outcome. This
That
would mean that the surcharge would not be added in the current energy charge, in the energy bills. So however, separate, however, the APDCL shall raise separate bills for surcharge. Within bracket, in dispute. Which will be subject to further orders of the court.
Well, the deposit, my lords, if it is otherwise appropriated, my lords, it can be adjusted in the future bills also.
No, the money is with you.
My lords.
You just don't adjust it against the bill, but you can use it.
My lords,
Not to appropriate does not mean that you can't utilize the money.
it's an observation to that effect, my lords, perhaps.
Is there difficulty in understanding?
My lords. Well, it's not to me, my lords, but the authorities perhaps, my lords.
No, you can convince them. You see, I gave you
It
10
can
rupees.
always be adjusted, my lords. If
No,
the,
no, you see, my father used to give me 10 rupees and say that you keep this money, don't eat anything when I was going to school. So this 10 rupees was with me. I would just have it, but not appropriate, not eat it. Appropriation means, you see, what happens is that the money goes away. It is entered in your accounts and then there can't be a reverse entry. There's a single entry system. I think your company maintains single entry or double entry accounting.
perhaps single end.
You just inquire.
But otherwise, it can always be adjusted, my lords, with the bills that with this
No,
pending.
no,
due,
there's a difficulty there.
subject to the outcome.
There's a difference between single entry and double entry system. Appropriate. Yes, sir. It is clarified that the money would not be appropriated against any bill. However, it will be open to the respondents to utilize the money as deemed fit and proper. Which is subject to outcome of, is subject to further orders that may pass in the regulation.
But what is the statement of the 23-6 order, madam? 23-6 order, Lordship, because there's name number of orders, madam.
The recovery, I think I have stated the recovery.
Yes. because they will not. Because
Just
by
like-
the 23/6, they talk about disconnections and all that.
No, we don't talk about disconnection. It's only with regard to
Actually, I
recovery.
think, if I missed it, I don't know, just
provision
like
is only with
the
regard
stay
to
of recovery. Subject to payment of so.
Well,
Mr. Chaudhary. While passing the orders, there was disruption. Please check it and then I'll sign it. It will be ready not before second half.
Yeah, please, your worship. My lord, here in this case, my lord, the
Just
factor,
just a minute, just a minute.
the father of the petitioner, my lord, this is father of the petitioner, purchased a land in 19.
So this is item 18. Yes,
My lord, the issue is, my lord,
where is the impugn order?
that the Indian order, my lord. Your lords will find in the Jamabandi copy that page number 23, my lord.
Page number 23.
Yes,
Is
upholding.
is the order passed according to you non-appealable order?
Yes, my lord, this is the order, my lord, that I am challenging because this
No,
order
that is
was
okay.
passed in 1996.
No, that is okay. You are challenging it here. My question is cast in a negative language. If I say it in positive language, it is that whether this order is appealable. And when I am saying it in negative, it means whether according to you, this order is non-appealable. Same thing. The orders passed in Jamabandi, are they appealable? Correction of land revenue records, are those order according to you appealable orders?
My lord, even if it is appealable, but it's still red judicial life because the jurisdiction of red court, my lord, it cannot be offset by the statutory provision that is under
No.
the land revenue regulation or
So
the-
from tomorrow, I'll call for the land records and I'll start passing orders in the land revenue matters. Correction of Jamabandi,
No, my
Chitta.
lord, here, I am not actually, my only prayer before this court is, my lord, for consideration of the representation that I made.
No, no, no.
before the
In
authority, my lord.
land revenue, anything is done in representation.
No, my lord,
If no,
because,
no,
my lord, what is my case, my lord? My father possessed.
no,
the
no,
land-
whatever your father or grandfather or great grandfather
My lord.
purchased. But tell me simple thing,
My lord.
in your experience as a lawyer,
My lord,
have you seen any order passed in land revenue cases
my lord.
on representation?
No, my lord, what is my case, my lord? Record was wrongly corrected in 96, whereas I ought to have been shown as a partner.
So on representation, it can be done, according to you.
My lord, wrongly corrected, showing me as a riot, my lord.
So according to you, under representation can be done.
Yes, my lord. So-
Okay, then hear the order. Yes, anything to say?
So, my lord, there is a, even, actually, what is my case, my lord? As a purchaser, as a by way of a registered sale deed, as a purchaser of land, I got the title over the land, my lord. And my name ought to have been mutated as a partner, my lord. And even that was done in 1973. Immediately purchase of the land, my lord, my father's name was mutated in the record as a partner. In 96, the settlement officer, my lord, wrongly shown my father as a riot, my lord. Then again in 2008, my lord, when my father died, in place of my father, my name was my lord, mutated in the record, my lord. Then again, my lord, my name was also shown as a
That
riot.
order is a appealable order. And any order passed for correction of land record is a appealable order. Why is 147 there in the Assam Land and Revenue Regulation? Why it is there? Against the order of settlement officer, you can go in appeal. But when there is an appeal provided for, let us say, today the order is going against you.
My lord.
Assume that the order is going against you. Now you want to move the division bench of this court. You will file a representation before the registry.
My lord, I got this. Others, my lord, there is a provision also, even under the 1971 tenancy, temporarily settled as tenancy act, my lord. That act say, if, my lord, for conversion of the Rayati Patta into a Medi Patta, my lord, representation be made before the deputy commissioner, my lord. That is the provision, my lord. According to
That is for conversion.
for conversion,
So in
And my
conversion, that is not an appeal.
my lord. That is not the
You wanted to, you see, you have a right as a riot. You want to fructify that right.
my lord.
Correct.
Even
Then you write to the deputy commissioner representation. On the basis of that, Rayati case is registered,
yes,
and thereafter, on registration of an appropriate case,
my lord,
then you are given the landholder's right.
my lord. That is the
And,
provision,
and an order of the order passed in a Rayati case.
my lord.
For that, civil suit will not lie.
Yes,
You'll have to go and appeal before the,
before the deputy commissioner.
no. Then before the government.
Comment.
Yes.
Director of.
Yes. So
that-
instead of that, can you file a representation before the government?
Yes, my lord. That is the representation, my lord, and before your lordship, my lord, that only that representation be considered, that is page 29, my lord. Because here, my lord, my prayer was before the.
So that is why you see, I was going to reject it. Representation doesn't help me. Because everything can't be done on representation. When this appeal is provided for you, go in appeal. Appeal is something else, representation is something else. I'm not creating a new methodology by virtue of which on representation, land revenue records get altered. Because then today, somebody will give a representation, he has a long hand. The High Court land will be taken away by somebody else by representation. There's a lattice field, somebody will take it by way of a representation.
My lord, here
That
in
is
my,
not how
in my
the
case,
land
my lord,
revenue records are corrected.
there are my lord, two particularly two main facts, my lord. One is that my name.
You show me from the land revenue regulation that it can be done by representation. That is the long and short of it.
Yes, my lord, section 21, my lord, of the Assam Temporarily Settled Areas Tenancy Act, because if my father was shown as a riot and I was also shown as a riot, then for conversion of the Rayati Patta into a Medi Patta, my lord, then section 21 of the Assam Temporarily
So
Settled.
therefore you admit that you don't have a title except for Rayati.
Lordship, the pair is totally defined, Lordship. My lord, my parents.
No, that is why I'm asking him.
Lordship,
That is why I'm asking you.
Lordship.
You see, it is your case now, your argued case before this court is that in respect of Rayati rights,
My lord,
if you want a conversion,
my lord.
then you have to file a representation before the government, right?
Yes, my lord.
So it is an admitted case
Yes, my lord.
that you are a Rayat.
As of now, my lord, so far record shows, my lord.
Okay,
Otherwise, my predecessor, they were the purchaser of the land, my lord. I registered sale deed.
okay.
But at present, my lord, since my name is my lord, shown as a
No,
riot,
there's nothing called at present or at past.
my lord,
When you are making that submission, I'll record it.
my lord. As a Rayati Pattadar, my lord, I have applied for conversion of the
Okay,
Rayati
okay, done. Okay, then that will accept it.
Otherwise, Lordship, as per, we go by the pair portion, Lordship.
You're making a contradictory stand.
Lordship, and Lordship, the annexures, which is
But
made,
you see,
Lordship.
we respect the lawyers by saying that it's a learned lawyer has made the submission.
Lordship,
When a learned lawyer has made a submission, what is difficult to record it?
Lordship.
It amounts to amendment of the writ petition, will do it.
Also, he denied their annexure one was
I don't know. It is, you see, whatever is being transpired
Lordship, Lordship,
is before the open court,
Lordship, Lordship,
correct?
Lordship,
And he is asserting that he is Rayati right.
Lordship.
If he is right, if he is a Rayat, then he can give a representation for conversion of the land for Patta. So, that is good enough. Mr. M.A. Islam, learned counsel for the petitioner, and Mr. K. Gogoi, learned additional senior government advocate, appearing for
I am for Lordship.
the respondent number 2 and 3, and Ms. G. Hazarika, learned standing counsel for Revenue Department, appears for respondent number 1. Next paragraph. The case projected by the petitioner in the writ petition is to the effect that his deceased father had purchased a plot of land measuring 1 bigha dash 0 katha dash 1 becha covered by dag number 8 of Khatian number 8 in respect of new dag number 746 of Patta number 635 covered by village Saupata, SUAPATA, part Roman 4, Moza Bilasipara in the district of Dhogri, Assam. Full stop. The said land was purchased. As per the writ petition, it is projected that the said land was purchased by registered seal deed number 8953 dated 5/10/1967, and the name of the father of the petitioner was mutated in the record of rights by mutation order dated 21/7/1973. Full stop. The case projected in the writ petition is that in the year 1996, the assistant settlement officer, Bilasipara Revenue Circle, within bracket, respondent number 3, recorded the name of the father of the petitioner as Rayot, R-A-Y-O-T, of one Sona Ullah Munshi, S-O-N-A-U-L-L-A-H, Munshi, M-U-N-S-H-I. Instead of referring to him as a patadar, full stop, on the death of his father, the name of the petitioner was entered in the Rayati Khatiyan in place of his deceased father. Full stop. Accordingly, the petitioner has submitted a representation dated 3/5/2023 before the circle officer, Bilasipara Revenue Circle, within bracket respondent number 3, for correction of the land records and for conversion of Rayati Patta into the Miadi Patta. Next para. However, in a departure to the stand taken in the writ petition, the learned counsel for the petitioner has submitted that that insofar as the status of the petitioner as Rayat is concerned, the petitioner seeks to fructify, F-R-U-C-T, I-F-Y, fructify, they said right, to a landowner right, to a right of the landowner by applying for issuance of patta as a Rayat by perfecting his position. Stop. Accordingly, the learned counsel for the petitioner has prayed that that the representation of the petitioner dated 3/5/2023 for conversion of the Rayati Patta into a Miadi Patta may be considered. Next para. The contention of the learned counsel for the petitioner is questioned by the learned additional senior government advocate on the ground that the oral prayer is in departure to the stand taken in the writ petition. Next para. Be that as it may, as the petitioner, as the learned counsel for the petitioner asserts that the petitioner is not claiming as a claiming right as a patadar, as a owner of the land, but wants to perfect his right by conversion of the Rayati Patta to Rayati Khatiyan to a Patta holder, the court is of the considered opinion that keeping the matter pending before this court would not serve any purpose, and accordingly, issuance of notice on the respondents is dispensed with. Next para. As the petitioner has submitted a representation dated 3/5/2023 to the circle officer, Bilasipara Revenue Circle, within bracket respondent number 3, the said authority, on a receipt of certified copy of this order, shall consider the said representation to be one which is for conversion of Rayati rights to where is that provision?
As per section 23, it should be before a deputy commissioner also. As per section 23, Lordship.
It will be before the deputy commissioner,
Lordship.
not before the settlement officer.
No.
23 of,
23 of the Assam
Assam.
Temporary Settled Areas Tenancy Act 1971.
in this book, which page?
Uh,
No, it's okay.
Lordship, 645, Lordship.
Assam Temporary Settled Areas Tenancy Act,
Lordship, Lordship.
1971.
Lordship, Lordship. As per section 23, it should be before a deputy.
Just the
commissioner.
Shall treat this as representation as one. Under section. Twenty-three,
Lordship, Lordship.
under section 23 of the Assam within bracket temporarily settled areas bracket plus Tenancy Act from 1971 and forward the same to the deputy commissioner, Dhubri. If you consider the said representation to be one under section 23 of the Assam temporarily settled areas within the Tenancy Act 1971. By taking note of the fact that the petitioner before this court has relinquished the proprietary right flowing from the sale deed.
I said 12.
Page
Page 12, my lord.
12, Lordship, annex
Number
one.
8953 dated 5/10/1967. Full stop. On the registration of the next para, on registration of such Rahati case, the deputy commissioner Dhubri shall make an attempt to dispose of the said representation within an outer period of 4 months from the date of receipt of a certified copy of the order. And such orders will be passed in accordance with law.
Lordship.
Yes, sir. The petitioner shall produce a certified copy of this order before the respondent number 3, so as to enable the said authority to transmit the representation to the deputy commissioner. Dhubri.
Lordship.
Okay. Now you are aware what you have done.
Yes, my lord.
No,
I'm
it's okay.
satisfied, my lord.
Once you have understood, it's okay. My duty is only to ask you.
Oblige, my lord.
I'll take a break and come back. Because my experience in these miscellaneous matters which I have done is that within these 3 months, you will need a fresh. At my times, we used to wear, because my budget was very limited. I used to wear a naughty boy. That is the toughest shoes which can be used. And I can tell you, in one pair, you will not be able to do it. Full stop. The petitioner is in receipt of a notice of eviction dated Where is that?
10/7/20, page 27.
27.
10/7/23.
Okay, 10/7/2023. From the office of the circle officer, Dispute Revenue Circle. And accordingly, the Land Council for the petitioner appears that the petitioner may be dispossessed of the land which he is holding without disposal of his application for settlement. And accordingly, this writ petition is filed under Article 226 of the Constitution of India. Next, issue notice, including notice on the prayer for interim relief returnable on 11/8/2023. Requisite extra copies of the writ petition is served on the Learned State and Departmental Council in course of the day. Next, the petitioner shall take steps within 2 days for service of notice on respondent number. Who is the private respondent number? 4. By registered post with AD. In addition, notice shall be served on the said respondent by routing the process to the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next one. Till the next returnable date. The pendency of the writ petition shall not be a bar for the competent authority under the establishment of the Deputy Commissioner, Kamrup Metro. No, now it will be the District Commissioner, Kamrup Metro, to dispose of the petitioner's application for settlement submitted on 7/1/2023. Just a power command. Till the disposal of the representation or till the next returnable date. The petitioner shall not be evicted from the land. Where you have described your land?
That is in the notice itself there.
Huh?
Itself is there.
Described in the impugn notice
Yes, my tag number.
dated 10/7/2023.
Yes, ma'am.
See, that notice is also in persons to the honorable court, so that it's page 34 or so.
No,
The operating
that is-
person also.
it is again different aspect of that matter. I am not.
And notice also reflected that lossy as per that particular honorable court, so that also.
No, I understand when he has prior to that, he has filed an application for
Yes.
settlement.
It says that lordship, they have used the public route lordship. Construction has been made on a public land which is being used as a public road.
Just a moment.
And notice or issue.
Just
Sorry.
just a moment. Was the petitioner a party there?
No, man. I was not part.
He's 31.
Yes, ma'am.
I think he's not a party there.
Even the order itself reflects that. As per para so and so, they were illegally occupied their house, standing up on it and left the place. Those who are made party were left the place. I am not that one. Page 33, para 4. Page 33, para 4. The petitioner can submit that. In the meantime, that's when 11/12 have sold the land.
No, just this page 24 is the acknowledgement. Where is your application?
Application I have not. The application already this is submitted.
Even lordship, DAG number is similar lordship.
Huh?
DAG number
Same
is
DAG
the same DAG lordship. Page 34 lordship. Page
No,
34.
because the government if it is a government there will be
Yes, government
a
dark.
lot of land.
Government document.
And that exercise was done lordship on the basis of that lordship operative person paragraph 9 lordship. And notice also reflected that Lord, it is hereby give notice to you that you are illegally occupying government land and route under Dagnam so and so lordship.
No, he is not denying that.
I am not party in that.
He is not
I am
denying
not
that.
saying that whether it's party or not, lordship, but
Mr. Gogoi,
lordship.
he is not denying it.
Right. As per the notice, lordship, my lord may kindly page 27 once again, lordship. It's hereby give notice,
Page 27.
lordship. It is hereby give notice to you, lordship, fourth line, lordship. It is hereby give notice to you that you are illegally occupying government land and route under Dagnam so and so, lordship, so and so, lordship. And my lord may then kindly come to lordship, page 34, lordship. Page 34, paragraph 9, lordship. Lordship, second line, keeping in the view that the construction has been made on public land which is being used as a public route, lordship. Same contents is in the notice also, lordship. The respondent number 2 and 8 are directed to take necessary action against the same, keeping in view the physical verification made by the lot mandal. Entire exercise should be conducted in a period of 2 months, lordship. That was done, lordship, as per honorable court's direction, lordship.
And now, my lord, I will again take your lordship to
And
notice, my lord.
lordship,
Just a minute, let him complete.
notice also reflected that, lordship, they are occupying the government land which was as a route, lordship.
But Mr. Gogoi,
Lordship,
I find it very difficult
lordship,
because you come to this 32.
lordship.
Now it is the petitioner's case.
Lordship.
The respondent number, paragraph 2, 11 and 12 took advantage of the absence of the petitioner and occupied the land. So it is not the allegation against the petitioner. He may be occupying a land illegally, but this is not the subject matter of the writ petition.
Lordship, I am not, I am insisting only that part, lordship. The honorable court's direction part is that, lordship. To lordship cleared our public route, lordship. And as per paragraph 9 of the direction,
No,
lordship.
no, you see, order which is not passed in presence of the parties is not binding on them. If he does not have the notice, he could not have contested it, whether this is a private land or not. That was never adjudicated.
So on the basis of that, lordship, that particular notice was issued, he can reply that particular notice, lordship.
It's okay.
No,
We'll permit him to do it.
Lordship may,
We'll
lordship
permit
may
him to do
keep
it.
him,
We'll permit him to do it.
lordship. Whether he is occupying that, obstructing the public road or not, he can reply it, lordship.
Next one. The learned additional senior government advocate has referred to the contents of order dated 12/5/2023 passed in WBC 5715 of 2022. And it is submitted that as there is a mention made in the said order that constructions have been made on public land. An order was passed by the school for physical verification of the land by the lot mandal within a period of 2 months. So accordingly, is apprehension is expressed that the land of the petitioner may be covered by the order dated 12/5/2023 passed in WBC 5715 of 2022. Next paragraph. Be that as it may, the petitioner was not arrayed as a respondent in WBC 5715 of 2022. And therefore, how far the order dated 12/5/2023 passed in WBC 5715 of 2022 will be binding on the petitioner. The subject matter of adjudication. Nonetheless, as the learned government advocate as a additional senior government advocate has expressed his apprehension.
My lord, may I just
It
I
is
point out,
also provided that within the time of 2 weeks from today, the petitioner would submit his Shuka's reply pursuant to notice of eviction dated. Where is that?
Lordship, it is on page 27, Lordship.
27.
27.
Notice of
Lordship,
eviction.
just I point out in that particular notice, my lord may kindly see that it is a new encoder, Lordship. In
It's
earlier
okay.
petitioner,
No, it can't be a new encoder because prior to that, he has applied for
Lordship,
land mutation.
he has
That
applied
is
in the
January.
Vasundhara scheme, Lordship. Whether
January.
he has applied for that particular land or not, Lordship.
That you have to say, that you have to say, but
Lordship.
we have accepted your contention. We have asked him to file a reply.
Lordship.
Reply in respect of notice number DIS post stop 14/2017/1604 dated 10/7/2023. List on 11/8/2023.
Lordship. Within 2 weeks, my lord, I have to file reply, my lord. And that we are. eviction notice.
Actually, eviction
Oblige.
should not be evicted. Unless your representation is disposed of.
Yes, my lord, yeah, oblige, my lord.
If it is disposed
love-
of earlier,
I
then
love-
this order will not protect you.
Yes, my lord. I love.
Yes,
May please your lordships.
yes.
My lord, impugn order lordships, page 87 lordships. This impugn order is passed by the Guwahati Metropolitan Development Authority. Order dated 11/7/2023, your lordships. Now, lordship, in the last but second above paragraph, lordships, here it is, this. Therefore, I so and so do hereby direct Shri Dilip Kumar Thakuria, the writ petitioner lordships, honor of MS Thakuria Auto Wheels and his Jalukbari Guwahati as per power conferred under section 88 of the GMDA Act 1985 to demolish the unauthorized construction of the building constructed in violation of GMDA Act, zoning regulation and building bylaws made hereunder within 10 days of the receipt of the order, failing which GMDA will be free to proceed with the demolition of the unauthorized portion of building on its own without giving any further intimation, and expenses thereof shall be recovered from Shri Dilip Kumar Thakuria, owner of MS Thakuria Auto Wheels. Lordships, this originally property belongs to Satyavati Kakoti lordships. Satyavati Kakoti, page 90 lordship, 19 lordships. This page 19 lordships. This she has applied, she belongs to 32 Tharapur Gaon Panchayat. Lordship, at that time in 2006 lordships, she applied for construction of RCC building G+4. And accordingly, lordships, the permission was granted. NOC was issued to Satyavati Kakoti on 30
You are referring to page 19.
19 lordships.
See the point number 6 there, second last line.
The permission is not transferable, lordships. Lordship, I have purchased the land, I have purchased the property in 2016 to 2023 by 5 sale deeds, lordships.
Yes.
5 sale deeds. In the meanwhile, Satyavati Kakoti lordships expired, lordships. Now, lordships, I
Where
have
is that assessment order? Where is that assessment order in respect of this construction?
this is
Gram
the
Panchayat or somebody, they receive tax or something.
this
Some authority who has issued that construction certificate.
Lordship, at that time, that taxes, whatever taxes were required to be paid, it was paid by Satyavati Kakoti lordships.
No,
Now-
you see, there is a document by which I come to know, which I can find out the date when the house was completed. Where is that? Date of completion of construction. Where is that?
I have made the statement,
Yes.
that Satyavati Kakoti has obtained the NOC in 2006, and this NOC was valid for a period of 1 year. So Satyavati Kakoti lordships, immediately after obtaining the NOC lordships started the construction, and within the year 2006 and 2007, she has completed the
What is the,
construction.
what is the, how many floors are there in this house?
And lordships
How many floors are there in that building?
G+4 lordships.
G+4. You, please come to page 28.
Page 28 lordships.
Yes.
Lordship Satyavati Kakoti, she is the
Yes.
seller lordships,
Yes.
and Rupali Thakuria, my wife's name lordships. My wife's name. The property was purchased in the name of my wife lordship.
Yes. No, no, you see, 28, last, I don't know why my eyes goes to the last paragraph.
Whereas the
Where is
first
the owner of a RCC building on ground floor? Correct.
lordships,
Again, come to page 33. Again, this last paragraph,
lordships,
schedule of the flat. All that piece of residential flat being located in ground floor.
built up area of 2,600 square
Yes.
feet, super built up area
So
with car
therefore,
parking, spare on
therefore
the
I
ground
don't-
floor.
therefore the 4 floors I don't find. And that is why my question, when was it completed? You say that the vendor did it.
It was lordships during that period, it was built up lordships, and I purchased the entire
No,
property.
you did not purchase it. Once you don't purchase, there's no harm if it is demolished. You don't suffer any loss.
And also lordship, this area where it is located, it belongs to 32 Tharapur Gao Panchayat lordship. It does not come within the purview of GMDA lordships. And
No,
now
I think
this,
there's a notification which has engulfed this area into the part of GMD. GMC and GMD, it is now a ward of GMC. Right? Am I right?
Yes, it's a part of latest master plan law.
but this construction, it was done lordship during the year 2006, 2007. Not that
No,
When
I
the-
don't know. If it was done on that day, this is a sale deed at page 28 is of 21, 2016.
16 lordships.
So in 2016, the vendor does not dispose 4 stories. And I can tell you in 2016, it was a GMD area. When is the notification, Mr. Nayak?
That date I have to look up.
Huh?
That date I can. But lordship may kindly see page,
No, let him complete, Mr. Sharma. Let him complete.
Now lordships, this 2016 to 2023 lordships, 4 registered sale deeds were executed in my name. I purchased all the properties lordships. It is G+4 lordships. And now lordships, this is I got a notice, page 80 lordships, 16/8/2021 lordships. 16,
Yes,
80, page 80 lordships.
page
I
80.
got a notice, I was
Yes.
directed to submit the NOC, approved drawing and other relevant documents
Yes.
lordships. And sooner I got it lordships, then immediately lordships, in the next page, 81 lordships, I submitted all the documents. NOC in the name of Satyavati Kakoti and this drawing map, site plan. Then lordships, the Jabanbandi, then trace map, etc. lordships. And lordships, I have submitted the reply on 31/8/2021 lordships.
Okay.
And now lordships, thereafter lordships, a show cause notice was issued lordships. This show cause notice, page 83 lordships. Page 83,
83, yes.
19/5/2023 lordships. Here it was show cause notice, it was issued to me lordships. And lordships, accordingly, in page 84 lordships, I have submitted the reply lordships. In the show cause reply, I also annexed all the documents, and also in the show cause reply in page 86 lordships,
There I have mentioned that the area of GMC is equivalent to the area of GMDA, and I do not fall under the said ambit. The law of the Panchayati Raj Act 1994 is applicable to me, Lordships. Lordships, I cast the vote in the Gao Panchayat, not in the GMC election, Lordships. So as such, this notice cannot be issued to me, Lordships, because I come within the Assam Gao Panchayat Act 1994, Lordships, not the GMDA Act or GMC Act. Whenever that election is conducted in Gao Panchayat, I cast the vote, Lordships, and accordingly, Lordships, in 2006, Satyavati Kakoti, Lordships, she applied for permission was granted, construction was done, and yet
So it doesn't match. Let me assure you, story doesn't match. Come to page 84.
page 84, Lordships.
Yes, 84.
This is my reply.
Yes, again, last
16
paragraph.
I,
Again, last paragraph.
Lordships.
Why,
that I
why every
exposed-
time in your case, I don't know. In this case, why always last paragraph is coming in, I don't know.
That I approached to the architect, engineer, and consultant who are
During the year 2006.
2006 for
So
drawing
therefore,
plans.
2006, it is your case that that Satyavati Kakoti made the house. Then why did you approach the architect?
It should have been Satyavati Kakoti, Lordships.
It's my bad
As a
habit.
typographical,
It's my bad habit. I don't know. Yes, Mr. Nayak.
and also, Lordship, this plot within the commercial area, Lordship. Commercial area, and I got the permission of commercial. My bill, that building, it is clearly shows commercial permission was granted, Lordships.
No, no, you see,
page-
come to page 80. Come to page 80. The violations are given.
Lordship.
There's a blockage of drain. Then there's a setback deviation.
In page 83, Lordship will get the exact deviation, Lordship.
83.
Yes, Lordship. Below, Lordship, manner of development construction.
Ground floor is
A,
constructed
ground
merged
floor
with
is
the plot
constructed
boundary.
merged with the plot boundary. And
Rear
B,
setback has been
rear
deviated
setback
by
has been
construction of
deviated by
toilet.
construction of toilet. Page 80, Lordship, it was done on the basis of a complaint, Lordship. Who are the complaint, Lordship will get at page 80, Lordship. Reference complaint letter from Bolen Chandra Thakuria,
Where you are reading where, Mr.
page 80, Lordship,
80.
80. Reference, Lordship. Complaint letter from Sri Bolen Chandra Thakuria, dated 27/7/2021. Now, Lordship, may kindly see the drawing at page 23.
Page 23.
Top, Lordship
Yes.
will see there land of Bolen Thakuria. So he is a on the boundary, Lordship, and there Lordship will see one setback area, Lordship.
Yes.
So this was constructed just to the boundary wall, Lordship, constructed merged with the plot boundary, Lordship.
Because if it is illegal construction, Mr. Sharma, we can't protect that.
Lordships, in the order in which portion it is divided, it is deviated, it is not clearly stated.
No, you
Lordships.
see, let me tell you,
It has to be clearly
No, no.
stated, Lordships.
your original notice was earlier. Earlier show cause notice contains everything. Is it required then in every notice, everything has to be spelled out?
This so cause notice, Lordships, which was received by me.
No, because
Lordships,
it leads me to a different issue altogether. You see, in a writ petition, when I am passing an order, I give some background of what the case is, whereas I am not required to. Correct. I'm not required to give details in my order when I'm issuing notice of motion. But I have developed a habit where I write 2 lines. Number one, so it's easy to me to remember why I'm passing the order. And number two, the counsel for both sides are aware why this order was passed, interim order was passed. That is my perception. I may be horribly wrong in giving details in the order. But let us say I have done it in one of the cases, but I have not spelled out everything. If I accept your contention that my order will be illegal, that in the writ petition, it was a 100-page writ petition. In the judgment, only 2 pages of notice of motion, where my entire 100 pages was not reflected. I'm just asking, I'm just thinking, I want to rectify myself. So what is to be done?
Lordship, page 87, that.
No, you see, in a communication, you have been told what is the deviation.
Lordship, here it is only mentioned to demolish the unauthorized construction of the building,
Yes.
but it has not spelled
So
out.
then,
in
then
which
make a
portion
measurement
is-
if any
It is
part is,
deviated, Lordship.
if any part is not deviated, they will not break it. But if there is a deviation, they will break it. Then you are not aggrieved. We'll ask them to measure. You see, it's a simple thing now which Mr. Nayak has simplified. Page 23, the back margin with the land of Bolan Thakuria is 1800. Correct. So anything below 1800 will not be demolished.
And Lordship, this is a commercial area, Lordships.
No,
Commercial
I
area,
understand.
already the building, it is constructed before 17 years, Lordship.
No, there's no dispute in understanding you. There's no difficulty in understanding
Not
you.
17, Lordship 2016, when he purchased
It's
the
okay.
plot.
Let us
was
say
only
it
a
is,
ground floor.
no, let us say, no, he has justified 2 other floors. First floor and second floor he has justified because in the other cell which I did not see, first floor and second floor is purchased. You see the next, I saw the one cell
Agreement,
deed
Lordship.
and I jumped into a conclusion. When he said that there are 4 cell deeds, I read all the 4. In the 4 cell deeds, number 1 says ground floor.
Yes.
There are 2 other cell deeds where there is a first floor and second floor. In one of the cell deeds, there is no floor.
Lordship,
You may take it. I've seen that.
Lordship.
Huh. So therefore, he has justified first and second floor. You see page 26 is the first cell deed. Come to page 33. This is ground floor.
Lordship.
Correct. The second cell deed starts 1 or 2 pages later. And in the schedule, which is at page 42, you will not find floor.
Yes, Lordship.
Correct. In the other cell deed, if you come to page 49,
Lordship.
now you will find first floor. Page 49. Correct. Now it is first floor. Now come to the last cell deed. Page 58. Here is the second floor. So don't worry. While flipping the pages, I was reading it. So therefore,
Second floor.
up to second floor. So we'll presume that it is the building of Mrs. Kakoti. We'll presume it for the today. It is built by Mrs. Kakoti. But her plan was 1800 meters originally, and 1800 meters or feet. What is that? 1800.
Lordship will see in the first deed, Lordship, it was 2600.
No, that is okay. This margin you are saying, Bolan Thakuria, page 23.
Lordship.
This is 1800 what? It will be 1800 feet or meter or square feet. I think you're referring to square.
In other portion, it is a meter, Lordship.
Meter. 1800 meters
1800 meters cannot be, Lordship.
cannot be. I think
This
it should be
calculated-
1.800.
This calculated in meter lordship. Below it is mentioned M. M means meter lordship.
M.
20.0 M. Wide.
1.8, I think.
Page 23. Page 20.0 M. Wide and it's 30.
Rasta to 20 meter. Road is 20 meter.
So if anything you are enclosed, that has to go. We'll take it up after 2 weeks. In the meantime, if you don't demolish it, then we'll take up the matter. To pass appropriate orders, but 2 weeks, the respondents would not demolish it.
Lordships, this repetition, it was filed on 20 July Lordships. The petitioner came to Honorable Guwahati High
Yes.
Court and the GMDA staff has gone to my property and took some measurement in my absence, which they cannot do Lordships.
Oh, no, we'll
Subsequently, I
permit
could
that.
come to know.
We'll justify that. In the order, if you want, we'll justify it. Because if it is an illegal demolition, you have given notice and they have gone there and they are measuring it. But they will not demolish it unless you yourself do it within 2 weeks. Otherwise, they will be free to take action. Illegal construction, we are not tolerating. Mr. Nayak, for 2 weeks, you don't do it. If they don't do it by themselves, then you do it. And give him a
We have
notice.
already given him 10 days time, Lordship. That 10 days has already expired. We are doing nothing, Lordship.
We'll give him time till
Lordship.
11/8.
Lordship. We will wait, Lordship.
Till 11/8, don't do it. If they don't, it doesn't make this setback clear, then you can proceed. Heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned standing counsel for the GMDA, appearing for respondent numbers
1, 2, and 3.
1, 2, and 3, and Mr. K. Goyal, an additional senior government advocate, appearing for respondent number 4. Next paragraph. Excelling the impugned order dated 11/7/2023, by which the illegal construction carried out on the land of the petitioner was ordered to be demolished within 10 days, failing which the GMDA forewarned the petitioner that the GMDA would proceed with the demolition of the unauthorized portion of the building on its own without giving any further intimation to the petitioner. The present petition has been filed under Article 226 of the Constitution of India. Issue notice, including notice of the prayer for interim relief, returnable on 11/8/2023. Requisite extra copies of the petition was served on the learned State and Departmental Council in course of the day. Next, the petitioner shall take steps in course of the day for service of notice on responding numbers 5 to 8 by registered post to the AD as well as by Basti. Affidavit. Next paragraph. Heard both sides on the prayer for interim relief. The opposing the questioning the legality of the impugned demolition order dated 11/7/2023. The learned counsel for the petitioner has submitted that the nature of illegal construction has not been disclosed in the said notice. The said contention is contested by the learned standing counsel for GMDA by referring to page 80 and 83 of the petition, which are letters dated 16/8/2021 and 19/5/2023, wherein the nature of illegal construction has been mentioned. First of all, it is submitted that as the show cause notices, as the show cause notices disclose the nature of unauthorized construction, comma, there is no necessity for the GMD to issue details of the illegal construction in all their subsequent notices, including the MP notice dated 11/7/2023. Next slide. Referring to the next one, referring to the NOC for construction, comma, the London Standing Council for the GMDA has submitted that the NOC for construction dated 30/11/2006 was not permissible. And it is submitted that as per the 4 sale deed annexed to the writ petition, comma, the petitioner has purportedly purchased the land as well as constructions which were standing on the ground floor, comma, first floor and second floor. Accordingly, it is submitted that the rest of the construction cannot be said to be in accordance with the NOC dated 30/11/2006. The said contention is contested by the London Council for the petitioner. Next paragraph. The London Council for the petitioner has also taken a ground that earlier when the construction was made, comma, the area was covered by a Gaon Panchayat, and that the petitioner has no notice of the said area being taken over under the control of under the jurisdiction of GMDA or GMC. In this regard, the London Standing Council for GMDA submits that he would produce the relevant notification on the next date. Next one, the London Standing Council for the GMDA has referred to the drawing annexed to the writ petition to submit that that as per the said drawing, the setback abutting ABUTTING, the land of Bolen Thakuria, PALEN Thakuria, is 1800, and the setback abutting the land of Mahinder, MAHIDHAR, Mohidhar Thakuria, is 2400. Next paragraph. The specific drawing disclosing the setbacks. The court is inclined to observe that it would be open to the petitioner to remove the illegal structures in the setback area within 11/8/2023, which is the next returnable date, failing which it will be open to the GMDA to proceed with the to proceed with the demolition in terms of the notice. By after recording the setback measurements in the presence of witnesses. First of the GMD shall also give a notice to the petitioner to remain on site for measurement. And if the petitioner remains absent at the appointed date and time, it will be open to the GMDA to make ex parte measurement of the legal construction. Next paragraph, according to comma. Till 11/8/2023, the GMDA shall not proceed with the demolition of the illegal construction made in the land of the petitioner without the leave of the court. Full stop. List on 11/8/2023.
Lordships, this GMDA may please be directed not to take any horse action, lordships.
No, till 11th you are saved,
Lordship.
subject to you doing it. But if you are not carrying out demolition of your structures, then what the next orders will be passed on 11/8. Because illegal construction I am not tolerating. If it is your what you call architectural design is there, if that is violated, then your house will be entitled to be demolished. It can't be saved.
Lordship, till
11/8,
Lordship.
you are protected from demolition by GMDA. But after that, you are not protected.
Oblige also.
You know, Mr. Sharma, you please try to reconsider whatever I have said. It may strongly go against you. Whatever I recorded in the order, it goes strongly against you, and I'll tell you why. Because in the order it has come that your construction is the purchase which you have made is up to 2nd floor. So therefore, any technicalities would cause immense damage to your other floors. But this is something I couldn't help. You understand the impact?
Lordships.
I can give you an alternative. Before I rise at 4,
Lordship.
you have a word with your petitioner, and if he wants to withdraw it, then I don't sign it. I can give you that much of protection. But these other things which are there in the record, that won't be reflected in the order. You have a word with your petitioner. I can permit you to withdraw the petition so that these are not recorded. Just take a call. I'm not putting you to difficulty, but this is what I feel. I thought, since you are otherwise a sincere counsel, I propose to give you some leeway. That is the only thing. Just take a call. I don't want the answer right now, but take a call. Oh, no, sorry. It will be 3:15. Before 3:15, I rise because today there is a reference. I'll be rising at 3:15. So prior to that, just tell us.
Lots.
Mr. Nayak,
Lots.
I don't want to disturb Mr. Sharma. I'm sorry, I was delayed. Yes, 13. Yes,
Lordship, I have challenged the ex parte order passed by the circle officer whereby office partition of my land has been cancelled. Lordship, Annexure A, page 12 of my petition is a copy of the Jamabandi, which will reflect that I am a co-pattadar and owner of a plot of land measuring 18 lacha. Page,
you see, these orders are appealable orders. Why should we interfere in writ petition?
Lordship,
Yes,
actually, it is a clear case of the violation of the principle of natural justice. No opportunity is given of being heard. Even then, before cancellation of this order, no intimation is made to me. Suddenly, I came to know from the online that order has been, office partition order has been cancelled.
where is the order?
This order, Lordship, impugned order.
Yes, no, which you have challenged, where is that order?
Yes, that order is on Annexure E,
Page, give me the page number.
page number 22, and the relevant person is on page number 23.
Twenty-three, yes,
Yes, Lordship. I'm reading out the vernacular one.
yes.
October 26/5/2000, sorry, 26/5/2023 তারিখত so and so হুকুম মর্মে 754 দাগর 0 বিঘা 0 কটা 18 লেচা মাটি আবুল কাসিম প্রামাণিকক নামত 360 নং পট্টা আৰু 1074 দাগত ভুলক্ৰমে হোৱা বাটোৱাৰা কৰ্তন কৰি পুৰণি দাগত বহাল ৰখা হল. And the earlier that office partition was allowed on my petition. Accordingly, they have created a separate patta. But suddenly they have passed this order that mistakenly it has been done. Lordship, being a applicant and the owner of the land, I should have a right to know what is the
Where is the
mistake.
document to show your ownership of the land?
This is the annexure A, page 12. It's a copy of the
No,
Jamabandi.
this is Jamabandi. Jamabandi is not a document of title.
That sale deed I have not annexed, Lordship.
Then,
Then I can annex it. I have it.
but this is something I will not understand. You see, come to the vernacular one at the next page. This is, this Jamabandi is issued only for the purpose of loan. This is something I don't know. Can Jamabandi be issued only for loan?
Page number.
Page number you have not given, I can't say. After page 12.
This original one, no?
हाँ,
Application.
केवल ऋणर भावे.
Yes.
What is this word? I can't say.
But
So
Lordship,
Prajyo.
yes, but the relevant, even then, the impugned order itself and the
No, if the land revenue records limit its application,
Then Lordship, I may be allowed to file the additional affidavit. I'll bring
I will
the,
bring it,
then I have a copy of the sale deed also.
bring it.
Yeah, Lordship.
And where is the order of partition? Where is that?
Yes. Annex that D,
Page
page 19, vernacular one.
19. But why are you not showing us the original order passed by the revenue authorities? If any order is passed in partition cases, there is a separate order sheet, not only the entry in the Jamabandi.
Order sheet, then I'll have to collect it, the certified copy.
Definitely, because you see, what is written in the Jamabandi is only a gist. It doesn't give a true picture.
Then Lordship, I'll collect it and
Yes.
2 weeks time may be given. I'll file
Okay.
additional affidavit.
Okay. On the prayer made by Mr. F.Z. Muzumdar, counsel for the petitioner, list after 2 weeks to enable him to collect additional documents and file it by way of an additional affidavit.
Obliged, Lordship.
And on the next date, you also come prepared on this issue of the appellate remedy available. Because you see, so far as my limited understanding is there, every order passed by the revenue authorities are bad in law. Because one side or the other challenges it in all cases. Because I have also learned my practice in that manner also indeed. First is revenue case, then take it to the Board of Revenue, Deputy Commissioner, then Board of Revenue, then come to 133, 145. If I exhaust all those remedy, then I come to civil court. So I have learned my practice in that manner, which was obviously the old school. Now you don't do it. Now you come for everything you come to the High Court. So this is how I have learned. Therefore, the original records, the original orders, so far as I am concerned, I find it very relevant. But that will also show that the instance, that the party at whose instance the Jamabandi, the partition has been cancelled and revoked, whether they were heard or not, that will come only in that.
As so far my information that no objection was filed. Even then.
No,
the
that is
proof-
okay.
proof-
Notice
proof
was served or
has
not, because
given
you
the
see,
consent also.
no, notice or not, that is why you see, I am asking you, the appeal is an appropriate remedy. The court, in order to find out, I've just indicated what more things I'll require. I'm just giving you an idea, because this is something which I have practically handled, so therefore I am aware. I may be wrong, but I am still aware. Because long time I have not done these things, so I may have forgotten many things.
Next day I try to make submit on that point.
Yes.
Obliged, Lordship.
20. Because if I find difficulty, Mr. Banik is there. I'll take his assistance. Yes. Item 20. Yes. Just a moment. Just a moment. Because in this case, I am inclined to interfere, because this impugn order, which you'll find that where is that page?
Page 50. Last
50?
50.
50. It doesn't give the two things. Number one, it does not give the amount of default. Number two, it does not give the floor value below which it can be sold. Correct. Because the properties of worth rupees 100, it can be sold for 2 rupees. Amount has to be mentioned. These are the two requirements. Okay. Okay. No, it's okay. Mr. J. Kalita, counsel for the petitioner, shall provide a extra copy of the petition to Mr. A. Das, standing counsel for the counsel only. Asha, on behalf of the standing counsel, that authority you have not got. Then we'll have to take steps. Okay. Appearing on behalf of Mr. N.C. Das, standing counsel for the respondent number 2, 3, and 4. Just to enable him to obtain instructions. List on day after tomorrow.
Yeah, tomorrow.
Day after tomorrow would be 26th.
26 plus. Plus.
Motion calling.
21.
21.
In this case, also.
I'll have to issue notice to the government and Mr. Kanduk, standing counsel for.
In this case, we have registered post to respond number 3 and 4. And Union of India, Mr. R.K. Chaudhary appears.
Okay,
And Mr. Mr. B.D. Goswami is appear for the respond number 2 and 5 in the.
no, it does not appear for two, because in the present, in the state, land management has a separate council. So you issue notice to the respondent number 2, they will engage whomever they want to. Correct. This matter is received on transfer from the Itanagar permanent bench. First, it appears that court notices have not been issued to the respondents. Next, heard Mr. A. Chetri, counsel for the petitioner. Next, Mr. R.K.D. Chaudhary Leonard, ASGA accepts notice on behalf of respondent number 1. Requisite extra copies of the writ petition is served on him within 2 days. Just add one more thing. And Mr. B.D. Goswami, Leonard, Additional Advocate General, accepts notice on behalf of respondent number 5. Extra copies within 2 days. Next para. The petitioner shall take steps for service of notice on respondent numbers 2, 3, and 4 by registered post to the AD. Full stop. In addition, the petitioner shall serve notice on respondent numbers 2 and 4 by Dasti, by routing the process to the registry of the court, and upon service, affidavit of service shall be filed that of the next list on
NSPC, 3 and 4.
NSPC. 3 and 4, but no. 3 you can't go to Haryana, you want to go.
No, see, in the registered post.
That I am around by registered post. I am saying only to 4. Correct. But if you want to go, we will provide. No. Okay. List on, give a fixed date, because this is outstation matter.
28.
Okay.
22. Item 48 is same one. Item 48 is also.
48 is same.
48.
Okay. 48 is motion matter.
48.
48 is motion matter.
No, orders it is come.
Just let me see the file.
I check the record.
It's okay. Just let me check up.
48.
Okay. In the meantime, I am taking up 22.
This IA is for implement of respondent number, opposite party number 1 and 2, my lord. The secretary. Secretary Land Revenue and Settlement, my lord, Karbi Anam Council. And the assistant settlement officer, my lord. Phase 5, phase 4.
Okay. No objection, we will complete. This interlocutory application has been filed for implementing the opposite party numbers 1 and 2 as respondent number 8 and 9 in the connected writ petition. Heard Mr. S.K. Deori, counsel for the petitioner. Sorry, applicant. And Mr. M. Chetia, government advocate, appearing for respondent numbers 3, 4, 5, and 6. And Ms. G. Hazarika and studying also for the Revenue Department, appearing for respondent number 1 and 2. In view of the nature of relief sought in the connected writ petition, this interlocutory application stands allowed by directing impeding of, by allowing impeding of opposite parties number 1 and 2 as respondent numbers 8 and 9 in the connected writ petition. In the connected writ petition, say, Mr. S.K. Devi, counsel for the petitioner, so and so, correspondent numbers. So and so. In view of the order passed today in the connected IA Civil 1911 of 2023, the opposite parties number 1 and 2 are permitted to be implemented as respondent numbers 8 and 9 in this writ petition. Next, issue notice on respondent numbers, the newly implemented respondent numbers 8 and 9 returnable in 4 weeks. Requisite, the petition shall take steps within 2 days for service of notice by registered post filing. Next, list on so and so.
Hello, regarding respondent number 4 or 7, we have taken a step, and as part of postal tracking reports, it was delivered on 27/6/2003.
For respondent number
7.
7. Acha. The petitioner has filed an additional affidavit to bring on record the postal track report, indicating that the postal article was delivered to the respondent number
7.
On 27/6/2023. So accordingly, notice on notice on respondent number 7 is deemed to be duly served. None appears and call for the said respondent. Next, list on list after 4 weeks.
Apply to that. My friend is appearing for newly.
You 8 and 9 you will be appearing. Okay, Mr. S. Camp, right? This is Karbi Angle Autonomous Council, Standing Council for KAC has accepted notice on behalf of respondent numbers 8 and 9, newly implemented respondent 8 and 9. Copy steps. Requisite extra copies of the petition was served on the Learned Standing Council in course of the day. This after
4 weeks.
4 weeks. The steps you are not required to take,
Yes.
right?
I will sub that. Apply to this.
Same order, huh?
Same.
48.
Senior is correspondent number 1.
It's the same order. I have recorded your presence in the earlier case. Okay, same order.
Observe this file.
23 for admission. Met with the watch.
Miller, the issue here
Just a moment.
relates to this safety and security of the life and properties of the petitioner, as well as the others who are residents of that locality. The Disaster Management Authority long back in
Just
2020 itself
just a
passed
moment.
some directions.
Just a moment.
Lordship last order is very
No,
clear.
no, just a moment. He has produced some instructions. Let me
Yes.
see it.
Affidavit has not come out yet.
Then we'll have to pass orders to direct the deputy commissioner to issue appropriate directions. No, once they don't do, then the authorities will have to do it and then recover the cost.
Exactly. They have not done it. That direction was issued long back, 2020 itself. And thereafter, they have also repeated it. Now the recent inspection report, Lordship must have seen it. My lord, it was placed with the affidavit by the soil conservation.
Another inspection.
Latest, which, when?
We'll, instead of that, I think we'll call for the personal appearance of these authorities. Affidavit for Director Soil Conservation. 19/7. What does it say? Soil Conservation is respondent number 4. What is the stand? Yes, yes.
At page.
No, because since my school days, I've seen these inspections and these commissions being carried out.
Long back.
With all respect. The announcement in newspapers I read, but the outcome, except for a recent commission chaired by the honorable retired judge of this court, I don't find the news reports indicating what happens in these joint inspections, joint commissions. Are you aware what they intend to do? No, I understand, but you see, this deputy commissioner will ask the disaster management will ask the chief secretary will ask the Latmandal will again ask from the Kanungo will again ask from the circle officer, and the cycle goes on and on. You remember a Hindi song? There's a great Hindi movie, a comedy movie by the name of Golmaal. You remember that? सीधे रास्ते की ये टेढ़ी ही चाल है. You hear that song, you'll love it.
That is what is going on here, Malay.
Huh?
Repeatedly, same thing is here. One will push it to another, he will push it.
No, we'll call for the personal appearance. Something has to be done. Huh? No, you see, you are producing documents and other things, but I don't understand how it will be implemented. I know,
Let
but
the
you
deputy
see,
commissioner be directed.
I can't. These are great people. Can I issue a direction to the deputy commissioner to protect life of someone? He may not like it. No, what I can do is that I can withhold the order till tomorrow. You by this time you discuss with the deputy commissioner, who's the authority in the land management department. If you can understand what I'm trying to say, that is well and good. You can ask him to look at today's video. Since I'm online, he can remember that song. And if he understands my point, that is okay. Otherwise, the order will go that he will have to be personally paid. No, but these things are, you see, nothing is happening.
Not happening, my lord.
Nothing.
And danger is looming large on my head.
Huh? You are referring to which letter? 21/7. Next is 28/7. Okay. So we are taking it around 31st of July. Correct. We want 7 days time as indicated in the letter. Because Mr. Mohanto, in this letter they say, on joint re-verification of the site of the by the circle officer, Dispur Revenue Circle, officials from the South Bank Soil Conservation Department and Forest Department, it has been observed that the said cut portion of the plot of land is still in vulnerable condition.
Yes.
And there is every possibility of landslide at any moment,
Exactly.
which may result into downward movement of the boundary wall of the petitioner
Yes.
and will cause damage to the life and property of the nearby inhabitants.
Yes.
Therefore, you are again asked to take all precautionary measures.
Yes.
All the following precautionary measures as suggested by the divisional officer South Bank Soil Conservation Department in order to stabilize the said plot of land and submit the action taken report at this end within 7 days without fail.
Well, the first directions, this has been the latest one, earlier also issued, but he has not paid it to.
No, it's okay. I'm recording it and saying
Then
that
what you will direct them invariably to see within 7 days what happens. Otherwise, because this is the responsibility of the deputy commissioner to do it under section 30. Then realize the cost from him.
Huh?
If he
no, because
defies
you
the
see,
order,
Mr. Setia, you see this letter dated 21/7. Although I have convinced Mr. Mahanto, but it doesn't inspire any confidence. You see, by this letter, the defaulter is being asked to do it,
yes,
correct? As if he is ready and willing to do it. There's a presumption by the government that he is ready and willing to do it.
no, those are there earlier
No, you
also,
see,
but he is
we'll
not paying.
issue a direction if they don't do it. He'll be prepared to get it done at the cost of the state and recover it from the
Yes,
officer as a land revenue. Otherwise, things are not happening. Who's appearing for this private respondent?
private respondent
This
is,
defaulter? Respondent number 7. Yes, so I'm putting you to notice that that is the order we are proposing to pass. If you default, then the state will do it at its own risk and cost and recover the amount from you as a aerial land revenue. Pardon me? We have taken note of everything.
because a heavy shower might lead to a disaster at any moment. That is the situation.
No, I
You
understand.
cannot brook any more delay.
You
I
have
came
cut the
before
hill,
this-
that is an admitted fact.
This is a fact.
Can you,
but-
can you deny that you have not cut it? So that is good enough. That only one statement is good enough that we have taken note of.
How can I allow him to cut?
Where is that agreement?
In the above petition, my lord, he promised to do some, take some measures before cutting and
Where is
after cutting. Annex 6, page 37,
37.
yes. Because we registered him, then he came down with this agreement, that I will do.
But then you alter the situation, Mr. Mahanto.
My lord,
If it is a breach of contract, then the only remedy is
no,
before
my
the
lord,
civil court.
there cannot be a contract allowing me
No, no,
or agreeing to his proposal
no,
to
that
cut
is
the art.
okay. But rightly or wrongly,
Damage
there is an
the-
agreement. If he's
Well,
breached the agreement,
That was on compulsion. What happened that when he had done it already overnight, in the night it was done. At night, overnight he has done it. In the morning when it was found, he was prevented that you cannot do it. Then he agreed that no, I'll do like this. I'll do like this. I'll take up all these measures. The second party agrees on the ground that RCC retaining guard wall should be constructed. That is what it is his promise. Not that I have given him consent.
no, you see, for breach of contract, writ petition will not lie.
Well,
That's
true.
why I said that you
I
altered
am
the
not on
position.
breach of contract, my lord. This is why, when I represented before the authorities have inquired into and found that, oh, well, it was a disaster really done by him. Therefore, he was directed that you do it, you take all these measures. And he promised here also that I will take these measures. To me as well as to the
No, then we'll
others.
take it up on, we are taking it up on 1st of August. You'll also have to argue on this issue of enforcement of the deed of agreement to a writ court.
Lord, I am not asking at the moment apparently to enforce this deed of, what I have shown is that there was a commitment made by him also. That he will take up
So
this
therefore,
repairing
it's
works.
whatever is there, it's a breach
Yes.
of promise.
He made a promise before before us to comply.
So therefore, it's a promise by a private person, and therefore a writ will essentially be on the individual.
Now, my lord, if that act only relates to me,
No, I'm
then
ready
of course I
to,
cannot.
I'm ready to hear the argument today. You want to do it today or you want to do it on 31st or 1st of August?
Now, if lordship says that lordship proposed to pass an order, If that
No, but
goes,
you choose whatever date you want, but the now situation is altered. When it comes to enforcement of the agreement,
yes,
then you take your, you choose your date. It can be tomorrow also. It can be tomorrow also. It can be Thursday also.
yes, my lord.
But
If lordship feels that this is coming in my way, I will have to satisfy your lordship that in fact, no, this will not
Yes.
come into our court.
yes,
It will
so
not
when you
come
want,
into.
you choose your date. There's a calendar in front of you. You choose a
Yes.
date. We'll give you a date of your convenience.
Tomorrow, if it is your lordship's board or day after tomorrow, Wednesday,
Day after tomorrow is
Thursday.
a motion day. We take it up
Thursday.
because this will take some time.
Thursday,
Thursday.
yes. Thursday, lordship may fix it. You want to?
Actually, these documents I want to like it. Simon, just give us, write your names in this slip. I'll get it recorded. In course of the proceedings today, the learned government advocate had produced a copy of communication bearing number DDMA space capital K within bracket M, again a space 42/2017, 6 to 9 dated 21/7/2023 by the additional deputy commissioner and CEO, District Disaster Management Authority, Kamrup Metropolitan. Addressed to the respondent number, you are respondent number 7. To take precautionary measures as indicated in the said letter within 7 days, failing which legal action would be failing which the respondent number 7 is forewarned of further legal action against him under the Disaster Management Act. The requirement being number 1, 2, 3. These are 3. 1, 2, 3. Next para. Needless to say that this additional CEO, additional deputy commissioner and CEO, his respondent number. The respondent number 3 shall 2. Okay, respondent number 2 shall pursue his communication dated 21 said communication dated 21/7/2023 and bring it to his logical conclusion. Next para. It has also come to the notice of the court that one of the issues which may arise for determination in this writ petition is that the respondent number 7 is in breach of the deed of agreement dated 2/2/2020 within bracket annexure 6. So therefore, whether the breach of contract can be a subject matter of adjudication in a writ petition shall be addressed by the learned senior counsel for the petition on the next date of listing. Next para list on when? Day after tomorrow, Thursday.
26, my lord,
Thursday.
Thursday.
26. No, it will be 27. 27/7/2023. My directions are twofold. Number 1, I have directed this authority shall follow up the communication and bring it to its logical conclusion. And this is the second part. So this order which he has done, he will continue with that. No, that you remind me of 7 days because I am now posting it for hearing on the preliminary issue. Because this goes according to me, the root of the matter.
If lordship grants them 7 days time, they want it, they're not returnable, that we will hear that point also. They will inform us and we will.
No, because you see, we can't, I'm not doing that for a different reason. There are, the impediment would be that I can't go into the merit and at the same time keep the preliminary issue pending. No, I understand your predicament, but the, no,
now
but
I
my
think-
problem would be that if I am taking up both the matters, preliminary hearing with the main issue, it may lead to some heartburning here or there.
Well, I understand it because if the preliminary issue is decided otherwise, then the second issue may not come in.
Second issue may not-
But otherwise, here, apparently distinctively, these are different issues. The authorities have.
No,
passed.
I'll hear you.
No,
I'll hear you. I'm not,
So therefore, to
I'm not saying-
expedite that aspect. After all, this is natural cause, which cannot be allowed to be dealt with in that
no,
manner.
that is okay, but
That is right.
the issue of breach, again, I'm too,
Lordship will be asking only the authorities who have already
As-
issued orders.
no, I'll tell you. Because then it essentially, according to me,
Yes,
I may be horribly wrong. It's just a passing idea,
yes.
specifically fact. Just a passing idea. Assuming it's a breach of agreement, then it would not lie. Number one. So independent of that, I have still,
That is
you
what-
have been able to persuade me to give an order that the authorities will bring it to the logical conclusion.
Exactly, man, because
So
prima
I'm
facie.
protecting you there, but
Because
petition
what
maintenance.
why I am submitting prima facie, the area which, or the issue which involves in the agreement is not a personal cause. That is what my
It's
concern,
okay.
yes, that is what.
Just see this 2 lines only in the,
Otherwise, Lordship is right in that way. Had it been a cause, something else than this, probably I would not have been.
no, there's another aspect. Too much of CPC makes a man slow.
So let us not go into
I
that
have
side.
not been able to come out of this. Mr. Mahanto, just 2 lines of this introduction. Just 2 lines.
Well, no dispute at all that.
Means that is what is coming.
Yes,
When I'm
but-
saying it, this is what
Okay,
is
well,
coming.
That is why I say, brother, prima facie, the issue involved is such here, which had it been a personal cause of mine.
It's
yes,
okay, we'll
I
take it
know.
up because today I'm constrained of time.
Yes,
Since I have to rise at 2:15,
yes,
we'll hear you on the,
yes, and that is why I say,
Page
brother,
26.
meanwhile, the steps they have taken, after all, this is for the.
I've directed them to take it to
for
logical
the other
conclusion.
people also. All the entire area.
That you have persuaded me to pass that order.
Yes, that they should.
That I passed.
Lordship will kindly
We'll
see.
take it up on 26th. Today I'm hard pressed of time.
Yes.
Next. This is a production list.
Item number 1, production list, item number 1.
Wait, please, Lordship.
Just a moment. Yes, can there be a part approval? Can there be a part approval?
On the face of it,
4 elected members are found ineligible.
Lordship.
How the said authority directed for fresh election, though candidature of election of rest of 11 have not been faulted with. That
It's
is,
not even countermanding, it's re-election.
you may go through it, we'll take it up after some time.
Director, it's for holding an election that has been cancelled. Earlier election has been cancelled. There is a direction for holding new election.
No, that is why Mr. Banik is here. His contention is that only 4 were defective. So why all the 11 were set aside?
In the meantime.
Means can it be saved? Can it be partly saved? This is something I'm not aware.
Another, if I may just apprise the Lordship on that. So far as election rules are concerned, 2019, talks about the concept of countermanding as also re-election. Now, both are distinct and different. Here, to form a board under section 35 of the Act, 15% should be there. Now, out of 15 to form a quorum, 50% is required. If 4 go, I'm not touching the 4. Rightly or wrongly, they are not be before your Lordship. Then it's 11. 50% of 11 would be roughly 6.5 or 5.56 if the quorum is there.
No,
Either ways, the quorum is there.
no, it will not be there because the board of directors has 15.
There's a part of co-op 3 also. Even if 15, it's 7.5. 7.5 is 8. If the 11 members are elected now, untouched, the election cannot be said to be gone.
No, I don't know.
That's the law, Milo. I'll place that. This is not a board meeting. This is election now.
You show it to him, we'll take it up after 5 minutes.
Show it to you later.
You show it to Mr. Talukdar, we'll take it up
I've
after
read
5
that
minutes.
also. I've
You
read
show it to him,
that.
point it out.
Right
We are
now?
taking it up in unlisted motion. You point it out to him,
Right now, it was also sometime.
Hi, yes, right now,
Right. It's not good. It is
after some time,
It's
because
a-
I'm constrained of
Not-
time today.
not-
Here, my lordship, my lord. The petitioner here, my lord, has a small shop, my lord. He just started a pharmacy in the midst of Lumding Bazaar, my lord. Earlier, year 1993, it was a panchayat area. In 1993, my lord, by the order of the governor, my lord, it was brought around.
But your synopsis is as long as your writ petition.
My lord,
Your synopsis is as long as your writ petition.
my lord, we have never read the Percy writing in grammar. We read. Because I am the product of Nehru, we are bound to read. So there is a difficulty nowadays, my lord. Otherwise, in my case, if I would have drafted it, my lord, it will be hardly 10 lines.
You should not go beyond a
Yes,
page.
yes.
Because otherwise,
My lord, Percy writing is very
if I-
important for you.
because Ms. Som, if I don't understand it, I don't give an interim order.
Yes.
That is the
That's
simple.
why I tell you every time that you send the drafting of the representation to me. Really,
But you
not
can't
a
do it.
computer.
You can't do it.
No,
Then we'll have to
my
question.
experts are there.
No, that is
What
okay,
the
but
guy
you
is
can't do it.
expert.
We will question you then. If you say that I will do it, then
No,
we'll question you.
I can bet it.
You can wait it.
Yes.
You can wait it.
I
But if you
can
start
hand over
doing
to
it, then
Adhikari, Rita,
we'll be very, very harsh on you.
then the Devasis, they are all expert writing. Right.
No, I don't disagree with you. But if you start doing it, then I will be harsh.
Whatever matter here, the plot of land was 18 feet by 12 feet. Tomorrow hardly about 200
No, but this is essentially a railway land.
No, not railway. You will also kindly come to page 27.
No, you come to the last page of your synopsis, second
Yes,
last
yes.
page of your synopsis. There you say thereafter having no
My lord,
recourse, the petitioner approached this
synopsis-
court
My lord,
by
yes,
way of
I-
a writ petition being
Yes.
so and so, praying for a declaration that the land of the petitioner with commercial house of so and so is belonging to the petitioner and not to demolish the same. So therefore, now you are essentially asking declaratory right.
My lord, you will also kindly come to page 27.
Page
Synopsis,
27.
let us forget my synopsis. Synopsis is, I have seen synopsis. It is a Mahabharata, right? Synopsis means what? Yes, 27, my lord.
Yes.
This is the order of the governor, my lord, dated in 1993, 7th April. MA number so and so 42 days from the date of publication of government notification so and so, the 1st January 1993 have already elapsed for filing any public opinion, objection, etc. Article 5(1) of the Assam Municipal Act so and so. Seeking public opinion, objection have been no public.
I'll tell you, Mr. Sharma.
So it was
You see,
Panchayat land, my lord.
you see, come to page 31.
31.
Yes.
Yes. Yes.
Yes. Now you say that I have purchased a plot of land, so and
Yes.
so.
Yes.
I have all this connection. How the railway authorities have threatened to come with bulldozer and demolish my property.
Yes.
As supposing to a railway land.
Yes.
And therefore, here again, you are saying that declaration be made that this land is a private land, your land.
Yes.
So that declaration can't be given by a writ court. I am not taking up adjudication and deciding right title and interest.
You are also not deciding. My question is, my lord, I am impugning the notice of sealing, not demolished. It is not demolished.
Where is that?
Well, impugn notice.
Where is that?
Page 37.
37.
Yes. Issued by the state officer, my lord, which is without jurisdiction. This is the what? 6/7/2023. They have dated, my lord. It was served on 17/7/2023. We filed the representation immediately on 19/7, my lord, and today it is listed on protection list. Sealing of premises occupied unauthorizedly by erecting structure on railway land at Lumding. This is the state officer. So if he is to exercise the power under Public Permission Act, my lord, he must go by section 5. There is no permission sealing. Earlier representation I have my lord, we became infected ballot. They had come to demolish it when I protested and showed that you saw this land it belongs to the railway land because it is a panchayat land. It was converted to municipal land in 1993. How can you claim to be railway land without any demarcation? There is no joint demarcation between the revenue authority and the railways.
No,
Let
that
them
is,
sit
that,
and
you
decide.
see, that is not even questioned.
Yes. This notice notice without jurisdiction. Therefore, my lord, the earlier replacement was became infructuous because they said, no, we will not demolish your shop.
You have a copy of your earlier writ petition?
Copy of the replacement. Order is the page 36.
No, order is there, but what is there? What is the prayer in the writ petition?
Against demolition, my lord. There was a threat of demolition, my lord. Asana,
So if it is infructuous, then your second writ petition will not lie.
my lord.
If there is a second writ petition, the writ petition would not lie.
Why?
Because it's dismissed for having rendered infructuous.
Infructuous in the sense they went for with a bulldozer to demolish. Then I immediately moved to High Court. High Court gave status quo. Then they withdrew their proposal for demolition. Now they have gone for sealing. Here's also cause of action.
No, they say that they will seal it. That means, you see that after land is taken over by the state,
Yes.
what is the prohibition in the owner of the land sealing it?
If the state officer is only power given to the state officer under 1971 Act, Public Fire Message Act.
Oh, that's right. You get this petition.
I have got a copy, my lord.
Huh?
Yes,
You have a copy?
yes,
Please pass it on.
yes. No, no. Original.
Mr. Sharma, just give it to me. Give it to me.
There is some, that was number no
Mr. Sharma,
Yes.
please give it to.
I don't know. I think it is, I don't know.
Give it to him. Give it to him.
Yes, it is high night. This is no number, man, nothing other. This
No,
is
it's
the-
okay.
Prayer or something, I see.
Just a moment.
Yes, 12 year loss of my Messi, my lord. Prayer portion, my lord. To start the operation of the improving action of demolition of the property by this and so. This was for demolition. There was no notice, simply they came for with bulldozer. Then we asked them to show the proof that it belongs to the railway land. They stopped it and we the petition was declared infructuous.
I'll tell you why. CBC give. There are two things which are coming in the way. Number one, order 2 rule 2. That principle applies in the writ petition also. That is one. Second is explanation 4 to section 11. Because you see what has happened in your first writ petition. I'll just indicate.
That is against demolition. proposed
No, no.
demolition.
In the first writ petition, you have made a prayer to direct the respondent authorities to declare the land of the petitioner with commercial house holding number so and so as belonging to the petitioner. Correct. So therefore, you are in a sense, you are asking for title of the land.
Okay, I am not.
This prayer now you have abandoned. This prayer now you have abandoned.
Yes.
So if you have abandoned it, that means that the fact that you are no longer seeking the declaratory right in your favor.
I cannot see. In writ petition, I cannot see.
No, but still you have made that, in your
no.
earlier writ petition, you have made that prayer. You take a call, we'll take it up tomorrow or day after tomorrow, whenever you want.
Declared right on in writ petition, it is
No,
not.
I understand, but rightly or wrongly, you have made the prayer and you have not withdrawn it by saying that you want to review the prayer.
Yes,
What you have said is
yes,
that the matter is you have permitted it to be allowed to be withdrawn as dismissed as infructuous.
yes.
So you address me if you want to do it today or you want to do it tomorrow or day after tomorrow, it's your choice.
No, today, we were 7 days notice is this.
Huh.
Today is
So
the
then
last
you
day.
argue the matter because I am absolutely dissatisfied on the maintainability.
I am on that, my lord, maintainability, it is a fresh cause of action. There was demolition against it, demolition is not there now. They simply want to seal my shop. The first cause of action. What is the bar, my lord? Case 37. And the state officer cannot do this. Either he will have to give notice under section 5 of the Public Premises Act. Or if he wants to evict me.
Yes, that you are right.
Yes. So I am on that one. He says selling. He claims to be state officer. If he is state officer, then he must give the notice under section 5 of the Public Premises Act.
Where is this notification of 2493? Where is that?
2490-27.
There's a notification of 2493.
I think it is. I think it is not 24. My lord. Oh, yes, page 27.
27.
Yes. It's a Panchayat land converted to municipal land in 93 on section 5(2) of the municipal act. Objection called for, nobody objected. If the railway had the objection, they could have made an objection there. They didn't make it. It was not a railway land matter. It is in the midst of the Lamning Bazaar matter, near Haplongpar river. And other side bounded by forest. Yeah. And there is a huge, many shops, my lord, made of the Lamning Bazaar. Newly extended area to municipal board, my lord, since 1993. And municipality is given, otherwise, my lord, municipal board would not have given permission, my lord, building permission, construction of the shop. Yes, 23. Yes, 23 is the my lord. Building permission by
Okay.
municipal board.
In the eviction, we protect him for 7 days. In the meantime, you obtain instruction. Who? Okay, because I have only 5 minutes time. I have only 5 minutes time. Try to see if you can be here.
Today is the last day, my lord. Otherwise, they will send it to you. They have given time till today. Till today, they have given time.
Okay. Just give him an instruction because he's otherwise right. Even if the rate petition is not maintainable, but still he has been able to demonstrate, Mr. Sharma has been able to demonstrate that notice under the Public Premises Eviction Act has not been given. So therefore, he will become entitled to stay, at least even temporarily, but
Yes.
for 7 days, he will be entitled to. You ask Mr. Chaudhary and come back.
After some time, my lord. So your lordship rising.
No, you wait for some time.
Yes.
Yes, supplementary 1. I'll issue a short notice then. And I'll say that insofar as since it will be a matter which can be adjudicated by the registrar of cooperative societies, we'll relegate him to. Huh? No, he can revisit his order.
He can.
Any difficulty in allowing the registrar to do it? No, I understand, but we can always interfere and send it back to reconsideration.
If lordship sends it back, there are 3 parts to it. First is that so far as those 4 elected members are concerned, I am not challenging on their behalf, number 1. So that stands. Number 2, so far as the direction by the registrar is concerned to take action against the authorities concerned, I have no locus to challenge, I have no challenge. What we have challenged is that the impact on the order on the election, on the return candidates, those 11, 7 before your lordship, that much protection. Because we are not faulted with our election, our candidates and nomination, nothing faulted with. Every time it was open as before the authorities and the persons concerned. Okay, stage by stage it came up. My entry period, page 16.
15. heard Mr. S. Banik, learned counsel for the petitioners, and Mr. S. K. Talukdar, learned standing counsel for the Corporation Department, appearing for all the respondents. Petitioners. Next paragraph. The legality of the order dated 4/7/2023 within bracket Annexure J, passed by the Registrar of Cooperative Societies Assam within bracket respondent number 2, is questioned in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. The challenge is made, amongst others, on the ground that that while the 4 elected members were found ineligible, which authority directed elections? The registrar
Cancel the approval
Cooperative
and directed.
Societies Assam within bracket respondent number 2, cancelled the election.
Approval.
Approval and directed a fresh election to be held. To stop. According to the learned counsel, the petitioner submits that insofar as 11 elected board of directors are concerned, their appointment was never under challenge or question.
Not nominations also, the validities of
It's okay.
nothing.
We don't have to say so much. Accordingly, not accordingly. Next paragraph, the learned counsel for the petitioner has clarified that he is not holding the brief for ineligible members or for any other relief save and except the cancellation of the election of 11 board of directors whose
Yes,
who were duly elected. So it is submitted that even if the 11 remaining board of directors are directed to prove their majority, there is every likelihood that they would still have the requisite majority.
11 can form a board and we
No.
can have a quorum also, anytime.
Majority, if you fall for majority, then it goes.
Once the 11 members come, the
Huh.
board is formed. Then for any meeting, board meeting, the quorum, concept of quorum will come. We'll have the quorum then also.
As the
And we are the part of.
as far as 11 board of members are concerned, they can constitute the board of directors
Yes,
of the Dakshin DAKSHIN Baguri Bari BAGURI BARI Gaon Panchayat Samavay Samiti Limited and would also and 11 members would also constitute the appropriate quorum. Full stop. Issue notice of motion written within 4 weeks. Requisite extra copies of the, we're not giving 4 weeks, we'll make it shorter.
shorter.
3 weeks. Requisite extra copies of the petition be served on the learning department council in course of the day. Next paragraph. The respondent, the pendency of the petition shall not be a bar for the petitioners to submit a fresh representation before the Registrar of Cooperative Societies, Assam, for revisiting the order dated 4/7/2023, insofar as setting aside the election of 11 member board of directors are concerned.
My lord, that in my most respectful submission, my lord, that might complicate the situation further because he has opined in one way, concluded in one way without divulging any reason whatsoever. Therefore, we are challenging that order. Lordship stays it, we proceed. End of the day, whatever happens, we take a call. By the law, I'm not by the record, by the law, nothing, not a word has been spelled out against us.
It's something.
I leave it to your lordship.
No, not that. Okay. Next, till the next return will date, the operation of the interim order dated 4/7/2023, insofar as setting aside the election of 11 board of directors are concerned, shall remain still.
I'm grateful. Obliged much.
When you say it very politely, it appears to be something fishy. Yes, Mr. Chaudhary. No, it's okay. Because in this matter, your colleague was here. She wanted the order to be passed in your presence. This Mr. Sharma has been able to convince that in this writ petition, please give him a copy. Please give him a copy of the writ petition. No, it's okay. Give it to him. No, we have called him. No, please give him a copy because I have called him. You see, maintainability is one thing of the writ petition. The second issue is that the impugn order is at last page. The state officer apparently has not issued a notice under the Public Premises Eviction Act. So apparently, even for 7 days, we'll have to stay it. What I understand from here is that the land belonged to the Gaon Panchayat. It was taken over by the municipality, and by encroaching the land of the municipality, they have done it. So number one, that it is a land of railways that you have to establish. Number one. Number two, even for eviction, notice under public premises has to be issued. So for that, for 7 days, we are staying it. Heard Mr. R.P. Sharma, Senior Counsel, assisted by Mr. T. Som, Counsel for the petitioner, and Mr. R.K.D. Chaudhary, CGC, appearing for the NF Railway authorities. Representing respondent number 1, 4. Five and 6. Also heard Mr. K. Gogoi, Additional Senior Government Advocate, appearing for respondent number 2. For municipal board also you can appear, no. For respondent number 2. Next paragraph. On the ground that the impugn notice dated, which is the page?
37.
37. Impugn notice dated 6/7/2023, passed by the state officer. The state officer is respondent number?
Last respondent, my lord. 6.
Respondent number so. Does not disclose issuance of notice under the Public Premises Eviction Act. The present writ petition has been filed in Article 226 of the Constitution of India, claiming that the land of the petitioner is his own land. Next paragraph. Keeping the issue of maintainability open in light of appears made in WPC 1354 of 2023, issue notice of motion returnable in 7 days or how much time? Returnable on today is 24. Returnable on 2/8/2023. Requisite extra copies of the writ petition be served on the Learned DSGI and the Learned Additional Senior Government Advocate in course of the day. Next paragraph. Heard all sides on the prayer for interim relief, which is opposed by the Learned DSGI and the Learned Additional Senior Government Advocate. The court is of the considered opinion that the impugn order does not disclose issuance of the registration of process under Public Premises Eviction Act, 1971, the operation of the impugn order, number so and so, page 37, dated 6/7/2023, shall remain state till the next returnable date. Next, list on so and so. I'm returning your petition, but you have to file it by your affidavit.
Yes.
So just I'll say next one, the list along with WBC that so and so. Yeah, I think list along with them. Tag the records of so and so, William Beckett disposed of. When with this petition, when the matter is next listed.
May I please, Lordship? May I please? Item number 63, I was mentioned, my lord.
Pardon me,
63. Item number 63.
Huh.
I was mentioned it, my lord.
you want to withdraw it?
No, no, my lord. Only notice. Notice
Oh, 60 that,
contempt,
okay,
sir.
so the contempt notice, pendency shall not be barred. Yes, Mr. Sharma, you got instructions?
Yes, instructed not to withdraw the petition.
Okay.
He is filing an additional affidavit.
Okay, okay, okay. No issue with that. Okay. No, I have, full court, sorry, there's a, full court. You tell, anything you have to say, please tell the court master one by one, give him some time to react.